Lordship, may I have your kind leave to mention one writ petition for inclusion in the list for hearing?
Motion matter? Hearing? Within my determination?
Yes,
Kindly
2015,
check.
Lordship.
But may be permitted for inclusion.
Obliged, Lordship.
Your Lordship determination.
Hearing or motion matter?
Motion.
May be permitted to mention, my lord, this is a land matter, encroachment upon PWD land. I already mentioned this matter before vacation when my lord was pleased to direct that this is a new motion matter, so it will come under the monthly list of June. But it is not in the monthly list, my lord. It's a new motion matter.
May I be permitted?
Item number 95 of today's list. You are for the writ petitioner. You are for the writ petitioner.
Grateful, my
So
lord.
it has to be released. At whose instance it has been listed before this court? তাহলে ওটাকে এনে আগামীকাল মোশন এনে এই টু বি মেনশন নিয়ে আসো লিস্ট করে দেবো আইটেম নাম্বার 95 টু বি মেনশন be that as it may. Anyway, it will be still another heading to be mentioned tomorrow. No, I am to release it, no. আমার তো land determination. Is a new motion matter? Motion matter? I don't have determination. Kindly check. Let the matter come tomorrow.
May I be permitted to mention, my lord?
Yes, sir.
On earlier occasion, my lord, Honorable Justice Shubhra Ghosh has directed to file both the parties to file the report and exception, my lord.
May I see the order? Yesterday's matter, no?
My lord, my lord. I have annexed the order.
নিচ্ছে তো এটা ওল্ড ম্যাটার নিচ্ছে দেখে নাও একবার লিস্টটা 2008 নিচ্ছে না 2008 এখানে 8 16 হবে 8টা হবে 16টা হবে না 16টা আবার কার ঘরে 16টা কার হয়ে গেল কে জানে দুটোই এখানে ছিল আগে
You have filed exception?
My lord. No, I have not filed. I have the exception is ready at the time of hearing. I shall file it.
You have sub copies?
My lord.
Let the matter appear under the same hearing on 13th March. Same hearing means what hearing? Same hearing means under what hearing? It was running before the coordinate bench?
It was running as motion, my lord.
আগামীকাল ফাইলটা নিয়ে আসো আমার কাছে নিয়ে এসে চেম্বারে নিয়ে আসো তারপর দেখে নিয়ে কি করতে হয় করবো
alright
let the file come
I'd like to mention two old matter my lord I mentioned this matter repeatedly my viewer is not appearing in this matter.
old matter hearing within my determination
Yes
কেন আসছে না কেন
that matter one matter another is my lord punch
হ্যাঁ আমাদের আছে আনি না
another is 2016
give the slip
16 not
My lord, may I have your lordship's kind leave to mention one urgent listed motion. I have given notice to the other side. But similar matter was pending due to appear on tomorrow. That is 11. Lord, the respondent
what is
authority.
the matter about
The respondent authority attempted to Lord forcibly dismantle the Lord bamboo fencing of the petitioners without taking any permission, and they are Lord the respondent authority has been trying to encroach the land of the petitioner without making any compensation. Well, a similar matter was moved, and my lord has been pleased to direct the matter to appear on 11th, that is tomorrow. Let the matter also Lord appear in tomorrow's list.
do you know the number
Yes, Lord, I have given Lord the numbers.
তাহলে ওইটা
It is appearing in the monthly list also.
it was directed to appear on
11th. It has
Under
been
the
marked
heading?
as 11.
under the heading
Motion. Lord.
fixed motion
Yes, Lord.
that number is there
Yes, I have given the numbers.
দেখে না ওটা যদি দিয়ে থাকে তাহলে ওইটার
874.
ওইটার সাথে এটাও নিয়ে আসো সেম হেডিং এ পরপর নিয়ে নাও
ঠিক আছে নোটিশও দিয়েছি I have given my lord.
Give a fresh notice
Yes.
in respect of this.
Yes, my lord.
Call the list. ফরওয়ার্ডস এর জন্য আছে হ্যাঁ ও no it has been disposed of by passing a direction by passing an order in open court. Matter was placed before me. I have corrected it, but I have not signed it. The draft has been corrected. Air Court has uploaded the draft copy. আসুন ওটাকে রিমুভ করাও করিয়ে এটাকে ডিকটেট করে আজকেই সই করে আজকেই আপলোড করবো ইউ আর ফর দি পিটিশন
Led by Mr. Saptanshu Basu, my lord.
ও এনিওয়ে কল দি লিস্ট
In this manner, my
Webটা কি হলো?
the petitioner. 2 p.m.
ও আচ্ছা আচ্ছা 13
Yes. I am appealing for the petitioner, my lord.
আমাদের স্টেটমেন্ট instruction of sending.
If your lordship may kindly turn to page 48.
Give me a second. Page number
48.
কিছু flag লাগিয়ে দাও yes sir
Initially, my lord, the proceedings was initiated under section 3 of the Act of 1948. The plot has been utilized for the purpose of construction of a road without declaring the award in terms of the statute.
no what is page number 48 Mr. Rai
48 is, my lord, pursuant to the direction passed by the honorable division bench. There is a direction to consider if you want to utilize the land.
no page number 48 is the a reply to your RTI
RTI. That is what, my lord, I am placing, the whether the it is finally acquired, award was declared or not.
After concerned draft award, if your lordship, may I read out for your lordship, my lord?
Yes, sir.
Revised estimate of 12 lakhs and odd was sanctioned by this office number such and such, collector Murshidabad, acres of land such and such. After concerned draft award was sent to the appropriate authority in the LR department for necessary approval, this office was directed by number to modify it as per the judgment or order such and such of the High Court in matter number such and such. Accordingly, another revised estimate amounting to such and such aforesaid acres of land sent to the RR department for necessary sanction by the office number, which is still pending for awaited. Pause there for a moment.
So for revised estimate of rupees 47 lakhs and odd is payable to whom?
Payable to the petitioner. Now, my lord, there is no question. Now, the act is not there. It is in the 2016-2017. This was said. So, therefore, my lord, in view of the operation of law, as on stand today, whether this land can be compensation can be granted in terms of the earlier statute or not.
No, that act is all very clear. ওটা দাও তো বাবা ওই আমাদের নতুন act 30 of 2033 right to fair compensation. Yes. So when the award was passed,
No, award was passed. In terms of the statute, the award required to be declared. বইটা কই? সমস্যা বইটা আছে তো, ওটা দিয়ে না।
section 24.
Yes, 24 malady. Here is under section 3, subsection 1. 9(3) proceedings was initiated, not been completed.
No, this award was passed in respect of which
No,
proceeding?
This is the estimated award which is, it is not declared.
Very good. In connection with
The proceedings under Act 2 of 1948.
Act 2 of 1948.
Yes. I'm not on 2013 Act. I am on the basis of the Act which was prevailing at that point in time, whether it stood lapse due to non-declaration of the award. 11A.
Have you brought the Act 2 of 1948?
And can you turn to, before that, one, can you turn to page 38? After that, one, it will clear to your lordship.
Yes.
Affidavit filed by the state in connection with contempt proceedings, because I have initiated the contempt for the purpose of whether they are willing to.
Page number?
Page 38 is a portion of the affidavit filed by the state in connection with the contempt proceedings. I state that compensation or rent compensation, man, got it? Oh, sorry, page 38, paragraph 6, subparagraph. I state the compensation or rent compensation in respect of the plots referred in paragraph 5 of the petition has not been paid earlier. The present petition filed another such and such against the acquisition of points respectively in respect of the plot number such and such passed by the Honorable Court such as in the manner of Gautam Chaudhary versus State of West Bengal Special Land Acquisition Officer Murshidabad initiated proceedings being case number 2 of 2014 on July 31st, 2014 and dispose of the same on August 28, 2014, directing the Assistant Land Acquisition Officer to take necessary steps on urgent basis to complete the instant proceedings under Section 9(3)(b) of the Land Acquisition Amendment Act 1997. Read with Land Acquisition Amendment Act 1990 preferably within 3 months. Accordingly, work has been started for declaration of the award. Inquiry has been completed as RA case number. It appears from the land schedule of the said case that the name of Gautam Chaudhary, son of some, has been noted as the name of provider of such and such. As soon as the award is declared on receipt of the fund from the requiring body, due to compensation will be paid to the petitioner. As soon award is declared on receipt of the fund from the requiring body, due compensation will be paid to the petitioner. It may be mentioned that in connection with the check bearing number such and such, as per estimated issued by the requiring body in favor of the district magistrate Murshidabad by mistake, the check should have been issued in favor of the land acquisition collector Murshidabad. The requiring body has therefore requested By maximum officer, Musha to issue a fresh check in the name of the amount, in the name of style of language, Musha check is yet to be received. Now, kindly takes up the provisional land regulation 9(3)(b). Now, if your lordship kindly takes up the
এই করলেন
From page 38, they are starting initiated proceedings for declaration of award.
the award has been published and compensation has been paid.
But that has to be, I have to take instruction.
Ah,
Without
that
instruction, I
way.
cannot say.
You submit a report.
Yes, ma'am.
Supported by
Report is
affidavit.
required.
I believe my judgment will be the guiding factor.
11A.
Huh?
That is why, I want to, that is why precisely by
My judgment is with you.
yes. My lord, once I can produce two judgments are there, my lord. One in my lord in Rajahat case, where your lordship was please told 17, what is the effect of section 17, and whether the acquisition, the declaration comes within the purview of section 17 or not.
Yes. I know.
And section 11A.
I have dealt with elaborately in that
Yes,
judgment.
yes. That's why I big both the judgments.
Very good. Thank you very much. Ashun.
My lord, I'm trying to disclose the date of the award. If at all
Let them
possible,
submit a
within
report
against-
supported by affidavit.
within 2 years it's not be complied with, then the possession should lapse.
Ah.
So if you want to utilize the land of that person, you have to initiate process under 2013 Act and take subsequent steps. That was the judgment. Mr. Pan was there arguing for the petitioner.
But kindly bring that judgment.
Yes, it's
My lord, I am for the petitioner. Initially, the total, my lord, 10,
Give me a second, sir. Who's for the state?
Mr. Supradin Dhar, learned senior advocate, have appeared.
Who is the advocate on record for the state?
Kakoli Noskar.
Where are
Last
they?
occasion, 21st May, my lord, they were appeared and fixed the matter on 10 July. Today is the 10th.
Pass over for 12 o'clock. In the meantime, you inform.
Yes, that's it.
এটা 12টার সময় রইল।
Lordship, I am for the petitioner, Lordship.
Who's for the state, madam?
Lordship, private respondent, you challenging your Lordship order. They have filed an appeal, and this is the order, Lordship.
Appeal disclosure of
Appeal,
directing us to remove the encroachment. And we remove the encroachment, and also I filed the report before the. No, what is writ petition for? Then
Here is the order, Lordship.
You have already removed the encroachment. ওটা কি চাও এখন? তোমার তো আর কিছু নেই তো, শেষ হয়ে গেছে। My lord, this matter has not any মানে fruitful result is there, my lord, and the appeal court has. No, what is writ petition for? দেখি কি অর্ডার দেখাচ্ছেন, দেখি উকিল বাবু বুঝতে পারছি না। Prayer of the writ petition, my lord, if your lordship will come to the prayer of the writ petition. That is directing the commanding the respondent authority, particularly respondent authority, to set aside the cancel the order and withdraw the order dated up. That is the demolition order. It is in connection with which matter?
This writ petition,
That
Lordship.
is my lord today's.
Today's
That
matter,
is
I
the item number 50. WPA number 2538 up to 25 to 20. No, the mat has been preferred challenging which order? Order of your lordship's order. Your lordship passed the order against that is the last order of the executive engineer of Hon'BLE private. Your lordship passed the order, and that order was set aside by the division bench, my lord, and directed us to remove the encroachment, and we removed the encroachment. Oh, there is an order of stay.
Yes,
my lord,
Lordship.
an order of stay. Against that order, my lord, the opposite party filed the appeal. So, my lord, this case has not any value, my lord, for that infrastructure. We have already demolished. No, this order has been challenged by whom? The private respondent in the instant writ petition. Well, I should mention that matter on the division bench that the writ petition is infructuous. I should say, my lord, but due to my mistake, my lord, that was not done. For that reason, my lord, that matter has come. What is the order which is under challenge?
That is appellate order, we are not.
No, appellate order, no.
Your lordship can see the order of the.
Page number
order
38.
of- In this case, my lord, your lordship will see the last order of your lordship. That is order dated 28. Your lordship passed the last order, my lord.
No, that I have seen, sir.
Against that
Kindly
order,
come to page number 38 of the writ petition. That order is under challenge before this court.
yes, my lord. 38. 38 to 40. And in this matter, my lord, in 39, it is clear that the private respondent of the above mentioned case are encroached of the government land of Willard plot number Atwana. Therefore, in compliance with the orders of the Honorable High Court, that is Calcutta respecting and considering the same, it is hereby ordered the necessary action for removal of encroachment from the government land in
I have passed an order of stay.
Yes,
Yes,
my lord.
lord.
Your lordship passed that order. And
Passed an
against
order of stay.
that- Yes, my lord. On
That stay order was vacated.
yes, not only vacated, my lord, that appeal was disposed of by directing us, my
The
lord.
state demolished the unauthorized construction of the appearing in plot number 1.
Yes, my lord.
So, yeah, practically, writ petition has become infructuous.
Yes, my lord.
Ashu. At the time. 16 who is appearing?
May it please, my lord. My lord, I am appearing on behalf of the petitioners, my lord. I, in the previous occasion, my lord, adjourned the matter on the ground that the respondent.
But in this matter, Mr. Osimada still matter for the state, my lord. He has not come to court due to his illness matter. We have not put everything.
Your other side is seeking an your other side is seeking an accommodation on the personal ground of the learned advocate for the.
Not today, my lord. Not today. I will not object to my learned senior friend. Not today.
Not today.
Much obliged, my lord. I am appearing on behalf of the petitioners, my lord. In the previous occasion, my lord.
You are for the state.
Lordship, led by Mr. Shantanu Kumar Mitra and learned GP.
I am appearing, my lord. My lord, am I audible to your lordship, my lord?
Yes, sir.
So, my lord, in this matter, your lordship recollects that, my lord, learned GP is leading us on behalf of the state government. My lord, learned GP, my lord, your lordship kindly fixes it after the 15th. He is out of station, my lord, kindly fixes it after 15th.
No, who is for the petitioner?
But there is nobody, my lord, I find, my lord. So, my lord, kindly
None
fixes
appears
it
on
on after
the-
15th, my lord.
None appears on behalf of the petitioners. However, the respondent state and its functionaries are represented. In view of such, let the matter be listed on
After 15th, my lord, subject to your lordship's convenience, my lord.
let the matter be listed on June 16, 2025 under the heading for dismissal.
Lordship, my lord. As your lordship, please. Grateful, my lord. After
I am for the petition.
I am for the state, my lord, led by Sheikh Mohammad Ghalib.
She am for the Union of India, led by Brajesh Kumar ji.
One supplementary affidavit, my lord. The railways, my lord, do have their own act, my lord, for acquisition.
My lord, only one thing I want to mention, my lord. Honorable Justice Aniruddha Roy on 6/3/2025 matter adjourned and the matter will come on July 2025. It's the order, my lord, if I'm not wrong.
The writ petition shall appear under the heading motion in the combined month list of June 2025.
June. Sorry, my lord.
My lord, the railway, my lord, do have
Give me a second. Yes.
But the railway do have their own act, my lord, for acquisition. But the benefit is that they provide in both.
Come closer to the microphone.
Sorry.
Adjust the microphone.
Yes, ma'am. They, my lord, the scheme is that, my lord, they provide in both the ways. But first, regarding the compensation, and second, they give, my lord, the land loser certificate by virtue of which we are entitled to, my lord, get the, my lord, compassionate appointment also.
My lord,
On land loser ground.
may I interrupt, my lord? My lord, I'm appearing on behalf of the Union of India, who's the main party railways, my lord. But they just now served a supplementary affidavit, my lord.
It's annexing only, my lord, regarding.
My lord, I need to fix it next week, my lord. I need to go with regard to the documents which they have.
Very well, my lord. May I just, my lord, place, my lord, before your lordship, what
You
is
are the respond numbers?
My lord, I'm the respondent railways. I'm appearing for the railways.
Respond number 1 to 4.
1 to 4, my lord. 1 to 4.
Why have not served copy in advance, sir? Matter is getting unnecessarily adjourned.
That my mistake.
Yes, 1
lord,
to
there-
4. You have filed report.
My lord,
Yes,
we have
yes,
filed
yes,
report,
report
my
for
lord.
clarifying
That
this.
has already been paid, my lord. This is a family dispute. For that reason, they have come up, my lord.
Objection in connection with the report. This is your exception.
My lord, no, this is, my lord, the
No, this is a
supplementary
They have given a
No,
supplementary
report,
affidavit. my lord.
report has been filed by the respond number 1 to 4.
Yes,
Yes,
It
my
is
lord.
exception. Objection in connection. There is an exception.
Yes.
Very good. Now what do you want?
My lord, they have today come up with a supplementary affidavit, my lord. I need to
My
go
lord, on
through
the
the
basis of
documents,
this,
my
my lord,
lord.
their report, my lord, I can argue before your lordship on the basis of their report itself.
Then why do we take it back?
Lord, kindly keeps it if necessary, my lord.
No,
If
yeah,
my
yeah,
learned friend wants,
no,
my
sir,
lord,
without giving
My
the
lord,
opportunity
my
to
lord, fix it next
deal
week,
with.
any day. Any day, take up this matter next week. We'll do it, my lord, because it's pending since long. We also want to dispose it of, my lord. My lord will take it, fix it up any day next week, my lord.
We'll file any additional report.
No, no, we don't need to file any additional report, but we need to go through the documents which they have. my lord.
very well, my lord, your lordship keeps it, my lord, on record, my lord. Let them give an opportunity, my lord. We shall come back on the next week itself. Because I want to rely upon, my lord, two of
You
the
don't, you want to file? No, I'll not record
No,
that.
no, I'll-
Otherwise, they will be prejudiced.
No,
The supplementary affidavit I first file on behalf.
If we want to file any, we will serve a copy,
Serve an
advance copy,
so that
my lord.
again the
So that
matter,
will be- my lord.
Mr. Mukherjee,
Yes,
be-
yes, sir. Definitely. Great.
19, my lord, I am for the petitioner. My lord, in this matter, I am seeking accommodation for 1 week at least.
1 week,
1 week. my
not
lord.
this week.
Grateful, my lord.
My lord, in this matter, what happened, my brief has been taken back by somebody from this court yesterday. So only I have got the writ petition.
Not this week.
Sir, আপনার থেকে একটু নিয়ে নেবো।
Not this week. Come, let him, let Mr. Ganguly come ready.
Lordship, I am for the petitioner. Your Lordship, in this matter, there is a
It's for the state.
But I'm appealing for the NHI.
Your Lordship, before your Lordship takes up the matter, there was a direction upon the NHA to serve a copy. Maybe it's my mistake as well. The copy I was not getting. Today, my friend has supplied me a copy of the report. Kindly give me this week time. Next week, I can complete the matter, Your Lordship.
You want to file an exception?
Yes. There's a,
Your report has been filed.
Yes, my lord.
On behalf of the writ petitioner, and accommodation has been paid.
Writ petition, my lord, I was supposed to file the affidavit of service today. My lord, kindly keeps it tomorrow or my day after, my lord, so that I can file the affidavit of service. I have reserved them.
Not this week. 10 তারিখ 12 তারিখ এটা একটা কাজ করো না as per request made by the who's for the petitioner? File that in, file that in. No, who is for the petitioner? That is the আগের দিন ওরা রিপ্রেজেন্ট করেনি inaction on the part of the authority, so they have to approach the tribunal. None appears on behalf of the
Father, I am for the state.
I am for the petition.
Is there any private respondent, sir?
My service is evicted, madam.
You are for the state?
Yes.
Who appears on behalf of the private respondent, sir?
Nobody appeared, madam. In earlier occasion also, nobody appeared. Service is evicted last time, except madam. Only one private respondent.
Vasudev Khatua.
Hello.
Give me a second. Yes.
My lord, against the unauthorized construction of the PWD land, my lord. That in front portion of the house of the petitioner raised an objection, my lord, page 31 and P3.
Page number?
31, my lord. Addressed to the all concerned authorities. Same is taken disposal that may be considered by the concerned assistant engineer and the jurisdictional BLR.
Your homestead land is situated RS and LR plot number 1390
My lord.
in Mauja Bajitpur.
My lord. Just in front portion of my said plot, The unauthorized construction was erected by the private respondent.
Erected illegal and unauthorized construction what the PW land by which egress and ingress has been blocked.
My lord.
PW4 is the appropriate authority to pass and
No, my lord.
initiate the order.
My lord, 3 is the appropriate authority. Assistant engineer, 3.
Oh, assistant engineer.
My lord.
Yes, my lord, assistant engineer has already taken step. He has directed the BLRO to, my lord, demarcate the land and supply the sketch map and supply the report. And thereafter, my lord, he will take the decision, and it was the, my lord,
When the letter was issued, where is the letter?
22nd April 2025. Thereafter, I have not yet got any further instructions.
22nd
April 2025. My lord, kindly see.
देखिए दाओ আসুন the affidavit of
My lord, I appear for the petitioner, my lord.
26.
My lord, I am led by Mr. Sudipto Dasgupta in this matter, my lord. He is engaged in court number 18, my lord. I am praying for a day's accommodation.
Not today.
Grateful, man.
Who is appearing on behalf of the 27? Pratima Ghosh. Dekhi file. The representative is not represented.
On behalf of Mr. Ranjan Bhattacharya, I am paying for only not today and tomorrow. He is out of station.
As per request made on behalf of the read petition.
Appearing for the state respondent, lordship.
I am appearing for the private respondent, ma'am.
Yes.
A petitioner purchased a piece of land from the private respondent. And that is at page 14, the deed. Thereafter, my
1-4.
Thereafter, my lord, he has mutated his name at his page 13, 1-3. That is annexure P1.
Give me a second.
Kindly sees.
জমি জমার মধ্যে বিকৃত 2 কাঠা 8 ছটাক কম বেশি জমির হারাহারি খাত। Where from we'll get the plot number? Kindly come to page number 17.
My lord.
Measurement of the land is 2 kata 8 chatas, more or less.
Yes.
In plot number O. Yes. LR plot number 370. JL number 65. Khotian Bhukto. Incomplete deed of
The LR plot number is appearing thereafter in the second paragraph in the land schedule.
Where, sir?
Khotian Bhukto, then RSO LR 84 নং দাগে শালি 46 শতকের মধ্যে 20 শতক
23 শতক তার মধ্যে 1 কাঠা জমি
and
ও
then RSO LR 75.
75
Those
75
are the
নম্বর
plot
দাগের
numbers, madam.
33 দাগের মধ্যে
LR plot number 84.
84 and 75, my lord.
Kindly comes to page 13 once, my lord. My lord will be clear enough.
No, I want to know the Khotian. Anyway, page number
13, 1-3.
13.
1-3, yes. Annexure P1.
Yes, sir.
This is the record of right. Kindly sees the Khotian number and Dag number is also given in details.
Khotian number is 865.
Yes.
Plot number is 75 and 84.
Yes.
It matches with the schedule.
Yes.
Very good. Then what happened, sir?
But thereafter, my lord.
So after purchase, you mutated your name.
My name. There is no difficulty. But kindly comes to page 23. I am paying Khajna also. There is no difficulty.
Very good.
Now the situation comes, my lord. Kindly comes to page 24 onwards. The PH department one fine morning comes, breaks open the boundary and constructs a pump house.
Hey. Have you received any report?
Lordship,
Well,
I am
I
for
am
the
for the
state.
private
Lordship,
Oh, I'm sorry.
I have the report, Lordship.
Yes.
Lordship permits, Lordship, from the third
Likhito.
para.
May I have the copy of the report?
Hand over a copy.
Yes.
Kindly place the report, madam.
Lordship, I have, Lordship, yes, Lordship. From the third para, Lordship, in this connection, Lordship, it is stated that one Kalidas Vishwas has gifted a land measuring about 2.5 kattas out of 6.4 kattas at Tripura Nagar Moza. In bracket, Lordship, it's written 75 and 84 Khatyan number 1264, Lordship. To the Public Health Engineering Department for construction of pump house located at Tripura Nagar, Moza, JL 65, Lordship. Under the Ram Gopalpur pipeline water supply scheme. Lordship, in the fourth para, Lordship, the petitioner herein had purchased purchased in the year 2014 the land of 2.8 cutters under LR and plot number 75. Khatyan number, Lordship, it's here. It's 865 and LR plot number 84. Khatyan number is 865, Lordship. Both the Khatyan numbers are different, Lordship. And
No one Kalidas Vishwas has gifted a land measuring about 2.5 katta.
Yes, Lordship.
In Moj plot number 71 Khotian 1264.
Yes, Lordship.
To the PHE.
Yes, Lordship.
This gift deed was executed on which day?
Lordship, it's
The petitioner herein had purchased in the year to the land measuring about 2 katta in LR plot number 7584 from one Torun
This is a
Vishwas.
non-gift deed. This is a notarized agreement copy.
Which one?
Which they are relying at page 10 of their
From one Torun which was has agreed to sell the same
is an agreement copy notarized.
to the said Kalidas Vishwas by entering into.
Lordship, both the Khatyan numbers are different. They are not similar, Lordship.
It's a unregistered notarized document wherein unsigned by in the page 11 my lord sees my client's name is reflecting, but in the signing portion there is nothing done.
No, what is this? It is an agreement for sale.
Baina potro is agreement. Jomi বিক্রয় চুক্তিপত্র বা
You
বায়না
are
পত্র?
Kalidas.
No, I am Kamini Mondol.
No, what is your deed, madam? The deed has been executed in your favor.
In the report he says so. Third paragraph.
Lordship,
Come with better particulars. I cannot follow.
He says about my deed that is there, but the gift deed.
Madam, kindly place the third paragraph. Place.
It stated that one Kalidas Vishwas has gifted a land measuring about 2.5 kattas out of 6.4 kattas. The close at Tirupura Nagar, Moza, plot number 75 and 84, Khatyan number 1264. To the Public Health Engineering Department for construction of 5 pump house located.
When it was gifted, where is your deed?
Not here with me, Lordship, at this moment, Lordship.
Why you come forward with an incomplete report, madam? You have purchased the deed from purchased the land from whom? From your client.
I have sold it to the petitioner, my lord. I am the private respondent. There is
Private
no-
is Torun বিশ্বাস.
Yes, my lord. I have sold, he has annexed the deed. My lord, with regard to this writ petition, there is no allegation against me.
I have not made
No
any.
relief has been claimed against me,
No, that I have understood.
my lord.
He has specifically stated that the Kalidas Vishwas has gifted them to PHE.
Let BLRO come with a report.
Yes. And further, my lord, kindly
Whether the alleged construction is going on.
But that has been completed. Now it is running pump house in my land. And in the report, it further says that lands are different.
You cannot understand.
The kindly sees the last portion. In view of the above, petitioner's land is situated together in different Khotiyan.
No, their case is that construction has been made in a different product, different area.
That's not true.
Cannot be.
That cannot be. It's my land. There is no other pump house in that locality. হ্যাঁ কতটা যাবে বাউন্ডেড তো বাউন্ডারি আমার তো বাউন্ডারি দেওয়া আছে বাউন্ডারি ওয়াল ভেঙে কনস্ট্রাকশন হয়েছে
Mr. De, I believe a report is required to be from the concerned PLRO from.
Yes, my lord. Now the position is that West Bengal DLR where the land records are account for commission. Now one man, one Khotiyan.
Yes.
That is, my lord, that the same land could not be there. There is a different land. Different Khotiyan, so different land is there, my lord. We are purchasing that is from Kalidas. And Kalidas, my lord, that is another person and another, his name was, my lord, in another in Khotiyan. So, my lord, the plot is not which my landed petitioner, my landed friend of the petitioner, my lord, claims that is not the land of this my lord. So this is a dispute between the land according to the portion, which portion that land is. That
So let BLRO submit a report. Otherwise, it will be difficult.
The porcha has not been created by me. Porcha has been created by Mr. De's client only. The porcha says that there are two plots of land. While the government is taking the revenue, has issued a porcha. The porcha specifically says there are two plots. Now the state cannot go beyond his own porcha.
No, sir. Porcha does not create any title.
No, title has been created by a deed. That is there in my favor.
Question is whether the alleged construction has been made over your property or not. Let BLRO submit a report.
File a report on affidavit. And if he founds, that will be taken care of.
May it please your lordship.
Sumita Paul and others.
The petitioner, my lord.
Is there any private respondent, sir?
No, man. There is no private respondent.
There is.
Private respondent.
Private respondent means a company is there.
Huh?
It is a GAIL. It is a case of acquisition, madam. Acquisition of land by the
Mhm.
Gas Authority of India Limited.
Chairman, Managing Director, GAIL.
GAIL.
Who is for the GAIL then?
Lordship.
Who is for the GAIL authority?
My lord, I am appearing respondent
Lordship,
member of Union of India, my lord.
But I have
So
served.
you are representing Union of India means
GAIL is some,
one-
my lord, I have served upon the GAIL authorities, my lord, and some other parties are there, my lord, for GAIL, my lord. But my lord, I have already served them, my lord. This affidavit service, my lord, is went for affirmation, my lord. May I just pray for leave, my lord, to file it within the course of this day?
No, no.
But may I just then
Get
take
it affirmed, then come.
my lord,
Not today.
Not today, my lord. Great. My lord, 30, identical.
Not 31.
Not 31, my lord.
Only 30, 32, and 33. Not today.
33, my lord, I am appearing for the state respondent. The same question, my lord, the GAIL, which is
No, their affidavit of service is not ready.
I will get it affirmed on back tomorrow.
Then your lordship is facing it tomorrow.
Well,
No,
Tomorrow or
or next week.
Tomorrow. It is ready, my lord, to went for affirmation.
32, 33.
GAIL ke serve করেছো GAIL ke?
I'm to satisfy myself with regard to the service of GAIL.
Yes, lordship, and the authority.
GAIL is the requiring body.
Lordship.
GAIL is the requiring body.
No,
Replying.
may I assist my lord? GAIL has taken over the land.
Yes,
They
lord.
called them, lord. So far in my petition, lord, for producing the document, they have not gone. I can argue with your lordship.
Very good. Let them come.
GAIL is the requiring body, my lord. GAIL
GAIL is the requiring. Man, I have served upon the GAIL
You are
authority. They
asked
have
to go.
contacted me, my lord.
Service upon the GAIL is completed.
Completed, my lord. And then someone is appearing, my lord, who have
GAIL
contacted me, my lord. I'll inform them, my lord, to come back tomorrow.
It's better.
I'll definitely.
GAIL ke bol.
GAIL ke বলেছে,
I will, my lord, definitely inform.
ওরা হলো answering respondent.
Then do একটা কাজ করুন তাহলে। Sorry, not tomorrow. Day after tomorrow করে রাখুন ওরা। Very good. Then come back on tomorrow. Item number 31. Call item number 31. 31 who is appearing?
And the petition.
Yes, sir.
It already acquired the land, but not compensate the petitioner. That is the
Acquired the land by a acquisition proceeding.
no acquisition. policy.
Utilized.
Utilized for enlarging the road.
Huh.
That is the several order has been passed, but no payment has been yet to be made.
No. Whether any you have filed submitted a representation.
Yes,
Reason order has been passed.
but yes, judgment has been given.
Yes, place your case.
So the case is, this is the case of acquiring land about 15 katas, and that has been approved by your honorable court, and already given an order that to give payment to the petitioner within 2 months, but no payment has yet to be done. Several orders have already been given to them. I have applied to them, and no payment has yet to be made.
Where is the order of the High Court?
My lord, previously page 34, if your lordship will see, page 34.
34.
34.
Now to consider and dispose of the representation within a period of 2 months. What happened thereafter?
After that, I have intimated the order to the respective authority, and that after that they give us assurance, but payment has not yet to be made. And they are not following the Supreme Court's latest order.
Oh. Mr. They come to page number 41. Point number 1, sir.
Yes, ma'am.
That on scrutiny of our office record and verification of overlapping register, it has been ascertained that the subject land involved in the instant reprisal has not been acquired previously under any land acquisition proceeding. Furthermore, it revealed from a communication of the Executive Engineer Barasat Division PWD addressed to such and such by memo number such and such that subject land of the repetition, it should be repetition, has been utilized for the development of Sahesanagar ki Kaijuri
My lord, may I
to
be
report of
permitted to-
procedural subdivision. So it has been utilized.
Yes, my lord. Or that is, my lord, I pray that your lordship can pass the order to the effect that the respondent executive engineer will, my lord, first demarcated how much the land was utilized. After
that has
that,
been
act-
demarcated. That has been demarcated.
And my lord, after that, giving him some, he can calculate the amount as because paragraph 15, if your lordship will see page 6.
Paragraph
15.
Huh.
That the petitioner claims the present market rate at the said property, which is settled by the Supreme Court of India. My lord, he annexed one judgment, my lord. According to him, he prays for market value, my lord. And after that, my lord, he assesses the market value and the executive engineer and send the matter deposit, my lord. The DM will deposit the amount to the according to the provision of my lord.
So after demarcation, what will
Whatever that he must calculate the amount
the
of the
is
TSR market rate.
that is response number 6.
Yes, my lord. Market rate, my lord, and send the and the DM will according to the provision of my lord direct purchase policy, my lord. We purchase he deposited the amount before the DM, and DM will purchase it according to the provision of direct purchase policy, my lord. Otherwise, he will not get the money, my lord. The lordship can pass the specific order.
But why not he will initiate a land acquisition collector will initiate a proceeding under the
As because,
Act
my
30
lord,
of 2013.
we are always, my lord, there are so many order passed by our honorable court, my lord, and we, my lord, file application for modification as because it is not possible for us to calculate the, as there is no any rule framed by the 2013, my lord, only for that act, my lord, we are direct purchase policy. And if you want, as my learned friend wants that, direct purchase policy, my lord, market rate, direct purchase policy, my lord, more than the market price. My learned friend, my lord, only prays for market price. I am solicited in his favor that a direct purchase policy, there is no any such, my lord, notification, other things, my lord, but only market price. But there is a direct purchase policy, my lord. For that reason, my lord, I pray before your lordship can pass that order. Otherwise, he will not. If your lordship pass the order that the new start a new proceeding according to the provision of Act 2013, my lord, then we must come still for modification. As we, my lord, filed so many applications before the other court, my lord. So, my lord, your lordship can pass that order. The direct affidavit of services filed today is taken on record.
private respondent, my lord, but
No, I have a Passover matter fixed at 12 o'clock. Call that matter first. কোনটা রেখেছিলাম Passover? Item number 14.
I am a state, my lord.
But I have served to the private respondent, remaining two private respondents. There are three affidavits. Initially, I have served all the private respondents.
Yes.
Total 10 private respondents, 8 has been received and 2 has not been received. Thereafter 21st May, my lord has been pleased to direct to again serve. My lord, I have intimated the 8 private respondents to matter will appear on 10th, and my lord, remaining 2, my lord, I have served along with petition. My lord, kindly see the status report, my lord. My lord, door is unlocked, and my lord, and one is my lord unclaimed. My lord, this is the remaining 2.
Dasarathi Das and Devabrata Das.
Yes, ma'am.
They are the respondent number
My lord,
8 and
17.
17.
Yes, ma'am. Initially, they are not received, but subsequently, their door is locked.
Item delivered to addressee. Another one is
Door is locked, unclaimed.
not claimed. Item returned, not claimed. Not claimed is a good service. And what about the other private respondents?
I thought initially, at first, I have served both the.
Give it.
8 has been received, and this is the another one, my lord. I have intimated them. The matter will appear in 10th June, my lord. This is
Before my court.
Yes, my lord.
Dekhi.
All the private respondents except Dasarathi Das and Devabrata Das, all the private respondent has been received.
Yes, sir. Where is your representation?
Page 38, my lord. The private respondents are illegally, my lord, occupy the PWD land and make a construction. For this reason, my lord, my ingress and egress has been totally blocked. I am not.
Where from will get the particulars of your land?
Yes, my lord, page 38, my lord, my recorded land being plot number.
Where is your pleading? Paragraph 3.
Yes, ma'am.
Recorded owner of such and such, privates are illegally occupying. Government land made an authorized council information. Any report is obtained from the BLRO?
From BLRO.
What does it say?
My lord, recorded status and physical status are different, my lord.
Come closer to the microphone.
Recorded status and physical status are different, my lord.
It has come to the knowledge that plot number have been acquired by PWD and presently existing over an acquired plot. Are illegally occupying the portion.
Illegally,
So it has been submitted before the assistant engineer.
yes, my lord. Demarcation is done, my lord.
Respondent number 7 will initiate a proceeding.
Yes, ma'am.
Yes, my lord.
Ashun. David subs
I am for the petition.
Well, I am for the private respondent,
Accompanying for
but
the statement.
landed advocate for the petitioner has not party in this writ application, my lord. Totally substance on material facts, my lord. He has filed this application, my lord.
Your lordship kindly
Earlier
hear out
occasion,
for a
Who is not a party?
I am the page 40, my lord. Private parties, my lord. Page 40.
কি
Writ
বলছিল?
application.
আমি কোনোদিন এটা অ্যাপিয়ার করিনি তো
আপনি স্টেটের হয়ে
হুম?
Your
আপনি
lordship
পিটিশনার
kindly
আছে
hear me
No, you have not been. I will hear you, of course. You have not been made party.
yes, my lord. My lord,
why I am
my lord, totally, my lord.
Very good. Let me see.
My lord,
What is his submission?
why I am not made a party, my
Give me a second, sir.
my lord, he has claim is rejected, my lord, by the authority. He has not annexed.
Have you filed any application seeking intervention?
No. But just now I have seen the list of this today's list, my lord.
It is an implement. It is for implementation of the earlier order.
Yes, no, my lord. Why?
Yes,
My
please.
petitioner land was acquired for preparation of a road.
Preparation of a
Road.
road.
My lord, his land was acquired. And suddenly, my lord, some encroacher encroached the government land. And for a result, my lord, petitioner ingress and egress is totally hampered. And he could not went to his right.
So land was acquired.
Land was acquired.
Huh.
Thereafter, my lord,
So land in the land was acquired. It vests with the government.
Yes.
It vests with the state.
Yes.
Then
Thereafter, my lord, some encroachers encroached the government land, and they have obstructed the petitioner ingress and egress. And petitioner made a representation. Thereafter, he came before this honorable court. Honorable court was pleased to direct the SDO to consider the petitioner's representation. My lord, after receiving the said order, SDO.
I am not clear on that point. In the event your property vested with the state,
Yes.
how you are aggrieved?
Yes, my lord. My ingress and egress is totally hampered.
Egress and ingress to which?
Well, in my royalty land.
Which has not been acquired?
No, which has not been acquired.
Oh, acha.
My lord, thereafter, my lord, is after receiving the honorable court's order, SDO started a 10-3 proceedings.
Under the West Bengal Highways Act.
Highway Act. My lord, in the said proceedings, he found that yes, encroachers are encroach the government land, and that should be vacated immediately. Thereafter, 10-4 proceedings was been initiated by the encroachers. My lord, in 10-4.
10-4 is the appeal.
Yes.
Before the district magistrate.
Before the district magistrate.
Huh.
And district magistrate also affirmed the SDO's order.
Very good.
My lord, thereafter, my lord, thereafter, my lord, the police has not given any police help. That's why, my lord, encroachers has not been vacated. That's why I came before your lordship. And why I am not made a party, my lord, as because both SDO and DM has determined that the encroachers encroaches the land. That's why, my lord, I have not made a party to the private respondent. Because they are the encroachers.
I am challenging.
They are not the landholder.
Have you challenged that in court?
Yes, my lord, I have challenged the order of the district magistrate. My case is pending before the lordships, my lord. List কত item number? Okay, I have challenged this order of my name's order. Pending is before your lordship, my lord. Item number কত বললেন? 358.
এই কোথায় গো? বললেন কোথায়?
Combined list, my lord.
এই 3-5 শুনে নেবো।
My lord, kindly liberty to file added in the private respondent. He has not party in this district.
No, my lord, they have the encroachers. My lord, first your lordship kindly hear out his application.
Thereafter, I shall see.
Yes.
Hey, what is your item number?
358.
In the month list?
Monthly list.
Very good.
Well, kindly day after tomorrow, my lord.
350.
Tomorrow.
Day after tomorrow, my lord.
Why tomorrow? Where is the difficult?
Well, service not completed, my lord. I have served the
No, my lord, tomorrow, my lord.
all the respondent, but receipt has not been till date, my lord.
No, he will appear, I believe. You have instruction to appear.
He is also not made a party.
My lord,
petition.
my lord, he has your claim has been rejected, my lord. My lord, kindly see my order.
No,
He has
may
not
I
annexed.
see the order of the district magistrate?
Yes, my lord, your lordship can you see?
এই একবার দিতে হবে একবার দেবে না
ওইটাতে দিয়েছে তার মানে ওইটাতে আপনি আছেন।
Page 44.
ওইটাও দেয়নি
ওটাও দেয়নি।
আগের রাউন্ডে
কিন্তু page 44.
তাহলে ছেড়ে দিন।
আমি ওকে দেখে আমি বুঝতে পেরেছি যে
Last paragraph.
Now, what happens thereafter? How
Thereafter,
proceeding?
Thereafter, my lord, assistant engineer requested the officer in charge, Purshuro police station, to give adequate police help.
Very good.
Police inspector.
Come tomorrow, come tomorrow.
My lord, one pair.
I shall sue,
Yes, my lord,
I
tomorrow.
shall case.
But day after tomorrow, my lord.
No, tomorrow.
well, I'm in a difficult situation. Why? Well, perhaps in the first round of writ petition, I did appear on behalf of the respondent. So I am recusing from this matter.
সেটা তো part over হয়ে গেছে।
সেটা part over হয়ে গেছে তবুও।
Anyway,
tomorrow.
এটা ওই আন্ডার দি হেডিং ফিক্স মোশন রাখবে। নোট করে নিয়েছো তো নম্বরটা? ফাইলটা পার করে নিয়ে নে। Give the number.
358.
There's the item number.
Yeah, item number.
Give the WPA number. In a slip. একটা উকিল লোকের স্লিপ দাও দিয়ে ওটা লিখে দিয়ে নিয়ে নিন।
একটা স্লিপ দিন তো। নাম্বারটা লিখে দিন।
Call the next matter.
Item number 35, I pay for not this week matter.
Why?
It is not completed matter.
Not this week.
35.
এখানে একটা দেয়ার আফটার লিখতে হবে বুঝলে? এখানে লিখতে হবে দেয়ার আফটার ম্যাটার্স ফ্রম দি এইভাবে লিখতে হয়। WPA 26748 of 2023 হালদার খন্ডে প্রাইভেট লিমিটেড ওটা পার করুন। ম্যাডাম ওটা নিয়ে নিন।
ডাকবে পিটিশনে ইয়ে ছিল না মিরানো আর কি
মিরানো
না মিরানো
যাবে নাকি?
Here for the respondent. রিপোর্টে চলে এসছে
প্রভিশন নেই, এক্সটেনশন নেই।
কোথায় আছে? Who is for the writ petitioner?
So Mr. Arwar is for the petitioner, but he is not here.
The petitioner is not represented. So let the matter be listed on June 16, 2025 under the heading for dismissal. June 16 June 2025 under the heading for dismissal.
Private respondent number 4.
Who is for the petitioner? 41 sir.
Yes.
41 অনিমা সাঁতরা নাকি? Writ petitioner? Hey, same date. Same order, same date. The petitioner is not represented. Let the matter be listed on June 16, 2025 under the heading for dismissal.
ডিসাইড করতে পারছে না কি করবে।
My lord, in item number 42, I am for the petitioner led by Mr. Patro. This is affidavit of service.
Who is for the state?
State has also been served, my lord.
Mr. Botobal, who is for the state here? তো মহা মুশকিলের ব্যাপার।
Whether the petitioner's land has been utilized for the purpose of construction of pilot pump house. My lord. Thereafter, representation was made, my lord. Neither the consent of the petitioner was obtained nor compensation was paid, my lord. Several representations were made, my lord, before the authority concerned. The representation were not considered, and thereafter one writ application before this honorable court was filed, my lord. And by order dated, my lord will find at page 23 the order of this honorable High Court, my lord, by honorable coordinate bench, my lord. At page 27, my lord, we'll find the order 11th March 2022. My lord, there was direction, my lord, to consider at page 27, second paragraph, my lord. My lord, upon consideration of the submission made on behalf of the petitioner and material on record, the writ petition is disposed of directing the fourth respondent. My lord will find the fourth respondent, the additional land acquisition officer, Nodia, to consider.
What he has done, sir?
My lord, thereafter, my lord, hearing was conducted, reasoned order was passed, and it was held that the irrigation department is not involved in this case. Therefore, petitioner's claim was not entertained.
Where is that order?
My lord, that order starts from page 29 onwards, and page 30, my lord, relevant portion, had the submission of, my lord, last two paragraphs from the bottom. Had the submission of both the parties and written depositions are obtained, the petitioners have wrongly implemented the Irrigation and Waterways Department with its subordinate office at Nodia Irrigation Department Division, Krishnanagar. Hence, it is ordered that the petitioner's claim is not justified and unproperly implemented to the Irrigation and, my lord, Waterways Department, alleging construction of deep tube well and pump house. The petition dated as per the direction of, my lord, that is disposed of by this manner, my lord. Thereafter, my lord, the concerned department is, my lord, the Water Resources Development and Investigation Department, my lord. And
No, here it has been, there appears as representative Atho. Irrigation and Waterways Department is not involved in the matter, wrongly implemented Atho.
Yes, my lord.
Then,
and accordingly, my lord, with the, my lord, appropriate authority, we made representation. All the petitioners before your lordship made representation before the authority concerned to the principal secretary. My lord will find that representation at page 33. Before that, my lord, also the assistant engineer was addressed.
Waters Resource Development and Investigation Department.
Yes, my lord. That is the
Agri irrigation.
Agri irrigation, my lord. And this representation, my lord, has
So what they have done?
My lord, thereafter, after making this representation, my lord, there is no steps taken by the authority concerned, my lord. My grievances with regard to this, my lord, to the extent that my representation has not been considered by the Principal Secretary, Water Resources Development and Investigation Department, my lord. Irrigation, my lord. They are the competent authority, my lord, to decide and dispose of my representation.
তথ্য দাগের সম্পত্তির উপরে বিশ্বস্ত সূত্রে জানতে পারলাম আপনার অধীনস্থ এগ্রি ইরিগেশন দপ্তর দ্বারা কার্য চালিয়ে দিচ্ছে। What type of work is going on?
Well, construction of pump house. My specific case, my lord, my property is a joint property, my lord, without obtaining my consent and also without, my lord, initiating any acquisition proceeding.
So who will consider then?
My lord, my last representation at page 33.
No, who will consider?
My lord, the assistant engineer, Agri Irrigation Department, Krishnanagar 1, my lord, copy was sent to him as well, my lord. Principally, it was sent to the principal secretary of the concerned department, my lord. At page 33, my lord, we'll find the representation, my lord. And this copy was also forwarded to the assistant engineer, my lord. Before that, at page 31, my lord, we'll find the typed copy as 31A. This similar representation was made to the assistant engineer, Agri Department, my lord, Agri Irrigation Department, Krishnanagar, Nodia. Therefore, my lord, these last representation made on 17th March 2023, my lord, should be considered by the authority concerned. Here, my lord, the respondent number 7, assistant engineer.
Your property is situated in which block?
My lord, it is block, my lord, it is not mentioned, my lord.
Then how
Tag number is
the work
mentioned,
of
my lord.
demarcation will be done?
My lord, demarcation, my lord, this is a joint property, it is a admitted position, my lord.
No, the jurisdiction BLRO given a complete idea, complete reflection in his report whether the property belongs to you or not. On the basis of that, the assistant engineer can do.
My lord, yes, my lord, I will produce my lord relevant documents which support in support of my ownership over the land in question. I am the recorded owner, my lord. My lord, can you consider the record of rights?
Show me the record of rights.
My lord, at page 19.
Dag number, plot number dilo. It is situated in which block? There is no averment.
And which block it is not there, my lord. Generally, my lord, by mentioning the Tag, Moja and jail number, generally we draft the writ petition, my lord. Block. Under which block, my lord, that is not mentioned here, my lord. That is right.
Ashun. The affidavit of
But in this matter, I am for the petitioner.
My lord, I beg to appear on behalf
But
of
the
the
matter
respondent.
relating to compensation of land. The father of the petitioner was the owner of the
Give
land.
me a second. Mr. Dotto is appearing on behalf of
The respondent, my lord, the railways.
Railway Authority. Yes.
My lord.
Yes, sir.
Yes, ma'am. The father of the petitioner of the owner of this land, and after his death in the year 2009, the petitioner became the owner, and her name has been recorded in the record of right. The railway authority, for the purpose of construction of railway line, has acquired this land, and they have been utilizing this land. But till date, compensation money has not been paid. And page my lord 24, the petitioner made representation before the authority, but they are sitting tight over this matter without taking any appropriate step, and no decision has been taken till that point. So let
Mr.
them take
Dotto, let them
decision.
take a decision.
Yes, my lord.
My lord, I will place sub things, my lord. My lord, this accusation, my lord, was, my lord, published in the year 2010. My lord will find out in the 2011, my lord, record of rights, which we have acquired, my lord. Yes, my lord, Amullo Paramanik, under whom this petitioner is claiming, consists of 6 acres of land. My lord will find out 6 acres of land. My lord has found out. Amullo, first, second, third. Amullo Paramanik.
Yes.
Yes, that he is having.
6
This,
acres.
they are the successor in interest of Amullo Paramanik, admitted fact.
Right.
My lord, as has been admitted by the petitioner herself, that Amullo Paramanik had 4 issues. 4 issues. So this, and most probably neither any will nor any probated copy of the will has come up to show that it has been given to the petitioner herself. My lord, petitioner.
What would be
No, my
what
lord.
would be the effect that in case of intestate succession?
In case of intestate succession, it will be divided into 4. And my lord will find out that in suppression, the other sister has also filed a writ. And in the said writ, my lord, and filed by the same set of advocate, Mr. Rejaul Alam.
Yes, all
And
become
my lord,
owner. After death of
suppressing
father,
this.
all are my
Let
land has
Mr.
been.
My Lanefant
Yes.
completes, then I'll come up.
Yes, yes.
What is your contention? You are the sole legal heir.
4 legal years, 3 daughters, 1 son.
Yes.
Separately, they are entitled after death of their father.
Exactly.
And their father died in the year 2009. Kindly have a look to page.
No, in your petition, you ought to have mentioned it.
I have mentioned. And in my representation also mentioned.
My lord, I couldn't find out that he has mentioned that same set of lawyers.
Kindly
He
have
has
a look to
mentioned
page
that he has filed another writ.
Page 24.
Page 24.
Yes.
That you have mentioned that.
No. So far your pleading is concerned, where from will get that your father or your predecessor in interest as left behind.
Yes, I have specifically mentioned.
Oh yes, paragraph 2 is there. After death of Amullo Paramanik, his 3 daughters,
yes,
Janaki, Bhavani, Shobita, Koyal Paramanik, and one became the owner.
And all are entitled.
All are, yes.
Yes.
So
equally entitled.
Yes, equally entitled. That has not been done because
I cannot deny it.
Milord, no, we are not denying it. Milord kindly comes to the record of right that has there, it has been filed, which they, Milord, have.
No, Mr. Dotto, you let your client take a decision.
Milord,
yes,
that is what I also intend, because this is the order being passed in another writ which have been suppressed here, Milord. Decision value to be taken. We are not
Call the next matter.
My lord, I am for the petitioner, my lord. My lord, respondent lordship.
I am for respondent number 4.
My lord, I am being led by Mr. Sundipon Banerjee, my lord. If your lordships kindly grants me 1 week time, my lord, since he has been engaged as a senior in this matter, my lord.
Awesome.
I am affair with the state, my
Yes.
After that, I'm waiting.
My lord, I am for the video. My lord, I beg my lord's pardon, my lord. On the last occasion, I failed to appear when the matter was called, my lord. I am to file my affidavit in reply, my lord. My lord, it is my fault, my lord.
Your affidavit reply is ready. I will serve copy.
I am serving now.
Give it, give it. The affidavit in reply as filed on behalf of the writ petition is taken on record. Let the matter be listed on
Stated.
The next matter. None appears on behalf of the writ petitioner. Next.
क्या नहीं है John?
The employees of the central government undertaking has formed an cooperative society. They have applied.
Yes, Mother. The question is.
They have applied and they have been selected in the lottery. On scrutiny of the document, it is found that you do not come under the purview of the applicants, qualified applicants, and accordingly your application was rejected.
Yes, Mother.
In the brochure, there is a clear indication that it is meant for the government employees.
That is their case, government employees.
It is meant. So far, I have understood. And in the say self-same procedure, who are the government employees? Those have been defined. You have to show that you come under those. You have to show that you come under those categories.
Absolutely.
And therefore their order, their communication is illegal, and you have to also satisfy that the classifications as made by the HITCO under the is violative of Article 14 of the Constitution of India. Am I correct, Mr. Mojumdar?
Absolutely. These 2 points only, my lord, I have to succeed if I want to get an order.
I believe you have got some idea that I have gone through.
Yes, absolutely.
For
Father.
you,
Both of us must be very obliged.
so be brief in your submission and be to the point.
I'll be brief, my lord. I'll be brief because my lord has already gone through the record.
Yes, sir.
So I should not take much pain to get your lordship go through each and every page, my lord. Before, my lord, I make my submission so far the facts of this case is concerned. Line of dates or the events are little important in this case, my lord. Why my lord, the line of dates is important? Because from that, perhaps, my lord, I would be able to project the act or the action or inaction on the part of the my lord, the HITCO. So far, our rejection of our claim is concerned. What happened, my lord, is aware of that in the year 2021, my lord, in my lord, in compliance of the one advertisement, we applied. We applied as in one of the applicants. So far, the allotment of land is concerned, my lord. In the month of June, my lord, the lottery was happened, and in the month of October, my lord, the result came out where, my lord, we among with others, my lord, the applicants, we got selected. So far, the drop lots is concerned, my lord. So we were informed in the month of August 2021 that you are selected. You then please come and submit the necessary documents. In the month of September, my lord, we went to the office of the HITCO and submitted all the documents in support of our, my lord, eligibility or, my lord, in support of our application. In the month of September, my lord, 2021. Thereafter, my lord, we are waiting with a bated breath. What is going to happen? Since in another 6 months, no result came, my lord. No, rather I should say no update came from the side of the HITCO. We again send them another letter. What is the status of my
this thing, my submission of documents, because so far in the meanwhile, my all other the successful applicants, they got their land allotment letter they have received.
Hmm.
So we got little anxious about our fate of our application. Well, there are no reply. In August 2021, my lord, suddenly we got a letter from the HITCO. I should say it is a so-called letter, where my lord, they have prima facie come to a finding that we are not eligible. They have held that you are not eligible, so therefore you satisfy, rather you file a reply and satisfy ourselves that you are indeed eligible. So in my lord, in reply thereto in the month of October 2021, we filed a reply. Thereafter again, my lord, there is no response from thereafter. Then in the month of January 2022, my lord, suddenly I got an, my lord, intimation that the application money that I deposited with the HITCO at the time of filing the application was refunded to my bank account.
Though in the brochure, there was a clear indication that money will not be refunded.
Forfeited.
Forfeited.
Be that is made.
Ultimately, they have not refunded, they have refunded.
Perhaps they have taken a plea, the equitable, my lord, consent they have taken, resorted to, and therefore they have refunded. Be that as it may, my lord. So I got that intimation, the refund of money has happened in the month of January. Again, I sent a letter to them the same month. Why you have refunded the money? We have already submitted all the documents. You have not come out with any reply so far our status of our application is concerned. Still no reply. Then we file a writ application, my lord. Before this particular writ petition, we file another writ petition. In that particular writ petition, when they came, that appeared in that case, then they, for the first time, we were told that our fate has already been seen way back in the month of January 2022.
Sorry.
Our fate has been
In the
seen.
said petition, what they have stated for the first
They
time?
have stated they have already, my lord, taken a decision, so and by way of cancelling our application, but no communication is there. Then was sought for the communication. Then, my lord, in the month of June 2022, in course of that pendency of that writ petition, my lord, the learned advocate appearing on behalf of the HITCO, my lord, sent one letter and communicated with that letter of, my lord, rejection that has been challenged before your lords.
So where is the unreasonableness? That I
No, I am coming, my lord. Definitely I will come, my lord. Why I am taking all
prior
this,
to that, may I know your good name, sir?
my lord, Devajyoti Bormon, my lord.
Yes, sir.
Yes. So for the dates, why I am harping on these dates, my lord, kindly see that they were aware of these things. Whatever I eligible or non-eligible, whatever as per their case, they did not take prompt action once we filed that, my lord, they submitted the document. And in course of my submission also, my lord, when we went for submitting the documents, while we got intimated of the letter of allotment, that I could say letter of, my lord, that we are one of the successful applicants, they scrutinized the document. And one of the top officers of the HITCO, my lord, that is one of the officers, general manager,
No, as per their report, scrutiny took place only after
the submission of the document.
No, after lottery.
After lottery.
Not at the time of filing of the application.
Very well. Be that as it may. After lottery. Then after lottery, we went there in the month of September when we got the letter. They scrutinized, accepted the papers, my lord. They right on the at that very moment, my lord, they could have rejected our application, because when they are accepting the document, there is a prima facie scrutiny of the document. We are submitting the documents, not that we can submit any ABCD XYZ document and they will accept it. They are acknowledging the receipt of the documents, my lord, and they are one of the top officers of the HITCO are acknowledging the receipt of the document. There must be some application of mine, otherwise perhaps they cannot take a plea. No, we did not go through the papers.
Where is the inapplication of mine? That I intend to know.
Yes,
where is the unreasonableness in their decision?
Once, my lord, that happened in the month of September 2021. They accepted my papers. They sat tight about the matter.
Acceptance of paper does not mean that you have come under the purview of the zone of consideration.
Absolutely. That is one of my pleas, my lord. When I am saying all these things, my lord, once they accept my papers in the month of September, they sat tight about the matter because they did not know what to do. I must
Sir,
say.
be that as it may, for the sake of argument, if I accept your contention that there was inordinate delay on the part of the respondent authority to communicate the decision regarding your cancellation of application. What I intend to know from the very beginning, I have clearly indicated. What is the unreasonableness in their decision? Kindly come to that point.
Let us see the my lord advertisement.
Yes, sir.
Because certainly my case does not, my lord, stand only on that plea that I have submitted a document they have accepted. I am aware of this, my lord.
Page number 28, I believe.
My lord, from my lord, it starts 28, 29, my lord. I'll read 29 and 30 once.
Yes, sir.
West Bengal Housing Infrastructure Development Corporation, HITCO, an enterprise under the Department of such and such Government of West Bengal invites online application for 2 types of housing cooperative society proposed to be formed under the West Bengal Cooperative Societies Act for allotment of 400 plots of land for residential use on 99 years as per the criteria detailed herein above. The said 2 categories are type 1 housing cooperative society exclusively by government employees including police, and type 2 housing cooperative formed by person non belonging to type 1. So my lord, the type 2 is for the common people and type 1 for the government employee.
We are for the present we are concerned with the type 1.
Type 1, yes. Now
Yes.
type 2 is also important, my lord, because
Very good.
previous occasion my senior friend had taken one plea, so perhaps I will try to cover that point, my lord.
Very good.
So but type 2 is concerned. So government employees, my lord. Nowhere mentioned is exclusively for the West Bengal government employees. Government employee. Why I am saying so, my lord? I have attached another, my lord, advertisement which they came out in the subsequent year, 2023. There, they, my lord, they have corrected the mistake, whatever the mistake they have done, if any, my lord. Here, my lord, kindly see page number 21 again. Formed exclusively by government employees, my lord. Government employees cannot in any means to be treated as a government of West Bengal employees. That is my first conception. Thereafter, my lord,
No. So far, page number 29 is concerned, formed exclusively by government including police. You read with page number 40.
yes, very well. I'll come to that, my lord. 40 I'll come. 1 by 38, 40, each
Very
every
good.
page I'll come.
You
my
do
lord.
it on your way, but don't lose the track.
My lord.
Be specific, sir.
My lord, very well. My lord, 29, the 30 kindly comes once again. HITCO is a government company such and such through the corporation has statewide mandate with immediate focus in development of a planned town near the city of Kolkata, New Town, Kolkata. Thereafter, my lord, can skip that page. Again, my lord, page number 30, they have mentioned government employees in bracket police, including police. Including police, my lord.
Right, sir.
Government employee, including police. I go by the simple, my lord, meaning of these words, my lord. I will not go try to dig into the matter and try to make a threadbare analysis. Whatever the words are mentioned, I will try to, my lord, interpret, my lord, into plain and simple way.
Very
Government employees, including police. Now, my lord is aware of 40, but before that, my lord, I will come to page number 38. Because that particular clause, Roman 12, they have relied upon once, my lord, they rejected my application, finally. Clause number 12, my lord. WB HITCO will conduct verification of the application. No stage has been mentioned, and can reject the application for factual errors or submission of wrong or incomplete supporting documents and or information. The applicants will need to ensure the correctness of the application. Full stop. Rejected application will not be considered for allotment. The application money and any other fees paid will be forfeited in such cases of rejection. This is the, my lord, clause whereupon, my lord, the application was finally cancelled. Whether this will apply or not, my lord, I will, my lord, make a submission at the later part of my argument, my lord. Thereafter, my lord, Roman 16, my lord, that will support their case. Successful applicants will be issued a letter of allotment after verification of documents. I have no quarrel with this thing, my lord, though the clause 12 is little vague so far the stage of the verification, but they have clarified in 16, clause number 16, that only after verification they will the final letter of allotment would be issued. Now, my lord, kindly comes to page number 40, where they have defined government employee. The crux of the matter perhaps is lying here, my lord.
Yes.
Type 1 housing cooperative society, type 2 housing cooperative society formed by not. The term government employees includes police will be defined as follows. West Bengal government employees including police, admittedly we are not falling in that group. Teaching and non-teaching employees of government of West Bengal, aided educational institute, it is nobody's case, my lord, we fall in that group. Thereafter, employees of statutory bodies in West Bengal. We are, my lord, applying under this category. Rather, we applied at the very inception under this category. Statutory bodies in West Bengal, my lord. Most of the candidates, my lord, the applicants are, my lord, the employees of food.
Now let us come to the come to your pleading.
My lord, which part?
Your pleading, sir.
Oh yes, my lord. Then it is, my lord, admitted case, my lord. We have
No. Let us see your pleading. Come to paragraph 7. Sorry, I'm guiding you,
No,
rather.
no, perhaps I'm really obliged, my lord. Maybe I'm missing anything. Yes, my lord. Those are mentioned, my lord, works as managing.
Kindly place paragraph 7.
Yes.
Kindly place paragraph 7.
Yes, my lord. That the petitioner state that they are all employees of various statutory organization of the Government of India, that is Food Corporation of India, Civil Aviation Sector and Labour Welfare Organization, and each having income of more than 80,000 per month. Thereafter, my lord, the first one, the total 7 members, my lord. First one is, my lord, the Food Corporation of India. Second one is also Food Corporation of India. Third one is also Food Corporation of India. Fourth one is also Food Corporation of India. Fifth one is also Food Corporation of India. Sixth one is also Food Corporation of India. Seventh was in, my lord, the Civil Aviation, that is the, my lord, Office of Deputy Directorate of General Civil Aviation. And eighth is, my lord, the Labour Welfare Organization, Government of India. So far, my lord, the statutory body in West Bengal, my lord, is concerned, my lord. This is admitted case, my lord. This is the Food Corporation of India is one of the statutory bodies, and they have their own zonal office in West, my lord, in the state of West Bengal.
Employees of statutory bodies in West Bengal.
Yes, my lord, the Food Corporation of India is a statutory body that is there. It is situated in West Bengal, my lord. They have got their 5 zonal offices.
Statutory body is a body corporate.
Yes, my
It's a
lord.
government undertaking body corporate.
Yes, my lord.
How it is a statutory body? It
My
is
lord,
not a creature of a
Food
statute.
Corporation, my lord, Food Corporation Act is there, my lord. This is a corporation. Corporation.
Sir, how a corporation can be a creature of a statute?
My lord,
Our
always,
Bar Council of India, Bar Council of West Bengal is a creature of statute.
my lord, Food Corporation of India
It is as a Advocates Act, under the Advocates Act.
It is all, there is a Food Corporation Act is there, my lord. Under that of act only, my lord, the Food Corporation of India has been established, my lord. There is
But
a-
how your clients came under the employees of statutory bodies in West Bengal?
because they are working in, my lord, Food Corporation of India, my lord. Food Corporation of India is a statutory body. They had been established under the act of
Food Corporation of India
Act.
operates in the state of West Bengal
Yes,
only.
they have got 5, my lord, zonal office. They have got
No,
5
Food
zonal. One of
Corporation
them-
of India
They have-
operates in the territory of West Bengal only.
No, not only. They have got 5 zonal office. One of
It
the
is a
zonal-
government of India undertaking.
Yes, my lord. Government of India undertaking.
Then?
Not government of India taking. It is a central government, my lord, entity, but a statutory body in West Bengal, my lord. I am harping on the part, not statutory bodies of West Bengal, my lord. It is mentioned statutory bodies. I am a layman. I have seen the advertisement. I have seen that the statutory they have mentioned. They have came up with an advertisement. They have stated statutory bodies in West Bengal. They have mentioned. So I found that I am an employee of a statutory body, and my statutory body is situated in West Bengal. One of their zonal office. They have got 5 zonal office. One of the zonal office is headquartered in Kolkata, and it is situated in West Bengal. Thousands of employees are working in West Bengal. So that is why we went by this particular advertisement, my lord. Now, my lord, my learned senior friend, or this, my lord, the HITCO has come up with a defense. So far, their report on affidavit in opposition is concerned. They have taken a plea, my lord, the principle ejusdem generis or the society and society, that the meaning of a particular word is to be taken from the word associated by it. That is a general principle, my lord. So now the question is, my lord, that is the only defense, my lord, they have taken.
No, not the only. Not the only.
Mr. Mohin, they will get your chance.
So far, I understood, my lord, that is the, if I correct myself, that is one of the major grounds in my understanding, that since that particular.
Mr. Burman, if we read the definition of the government employees as available in the procedure, we will find that the object of the allotment is to provide land
For the government.
to the government
West
employees.
Bengal, I should say West Bengal government employees.
Which by all government undertaking, panchayat, municipal corporation, municipalities.
Yes,
That is all the or either they are the functionaries of the state or the instrumentalities of the state.
Yes, my lord. That
How
I
a
can see.
central government of undertaking comes under this
Central
purview?
government is not mentioned, my lord, but since the statutory bodies in West Bengal is mentioned, my lord, and since I am one of the my employee is one of the statutory bodies in West Bengal, my lord, that is why we have applied. It is not mentioned statutory bodies of West Bengal. West Bengal is always represented by the government. The state cannot function. It is functioned by a government which is run by various political parties. So if had it been the case that statutory bodies of West Bengal, I could have easily understood, my lord, that is the state of my lord, the government of West Bengal. If any statutory body that belongs to government of West Bengal, then only those persons can apply. And even my lord, whether those persons can apply or not, that is my second leg of argument, my lord. Whether that is hit this particular clause, if you go by this, my lord, the proposition that has been my lord, put forward by the HEDCO, that this actually my lord, applying the principle of ejus generis of the society and society, that this particular line only means my lord, for the statutory bodies of government of West Bengal. Then,
That is subject matter of interpretation.
Yes, my lord. That is not only subject matter of interpretation, that whether that is hit by Article 14 or not. That is my second part.
That is very outside I said that.
Yes, absolutely, my lord. So, my lord, first my argument is, my lord, the society and necessity will not apply in this case because, my lord, the meaning is simple, plain. On a plain and simple reading, my lord, if I will take this particular part, then there is no ambiguity in my deepest of, my lord, respect and, my lord, understanding that the statutory bodies in West Bengal is no way, my lord, coming in the way so far my eligibility, my lord, for applying under this particular advertisement is concerned. Food crop is a statutory body and it is not a, my lord, it is not coming in the West Bengal. That is one part, my lord. And I will, my lord, cite to one or two decisions, my lord. Second is, my lord, as I was trying to, my lord, agitate that whether it is hit by Article 14 or not. If, my lord, I have to hit this particular clause, my lord, by Article 14, they have to show this is not a reasonable classification, rather it is a class legislation. They are trying to make a class among the classes. My lord knows that, my lord,
Give me a second.
Oh, before that, my lord, before I come to that Article 14, may I take your lordship, my lord, to the subsequent advertisement? Because they have, my lord, the plea that has been now taken by the HEDCO, that has been reflected in the subsequent advertisement.
But that is not the subject matter of the writ petition.
No, not the petition.
Why should I look into that?
Because they have mentioned exclusively for the government of West Bengal.
Very good. But that is not the subject matter of the writ
Right now, subject matter. I will just try to focus, my lord. It is not been for the state
No,
of West
maybe
Bengal.
because of this litigation they have
Maybe
become
they have
more
become
cautious.
wiser. But I'll take differently. I'll take, my lord. They did not mean, that is why they have not mentioned, my lord, government of West Bengal. Next occasion, my lord, they tried to mean it. That is why they have put.
Whether you come under this category or not, and whether this classification is unreasonable or not.
So, my lord, if it is a reasonable classification, my lord, it is a twin test, my lord. There has to be intelligible difference here. They have to show there has been a difference, category has been made, put under a separate and different category, not which can be easily identifiable from one
So
to.
then question arises, what prevented you to challenge the brochure at the stage of floating the same?
Perhaps,
Why you have so waiting for long?
Question came to me, my lord, yesterday. I vetted this application. Then I went to the pleading part. Luckily, my lord, perhaps it has been saved. I have challenged, perhaps consciously, the second advertisement only under this ground. Because first ground, I am agitating my rights because I am not claiming, because I am claiming under this advertisement my rights. So that is why, my lord, taken that plea not in respect of this advertisement. If, my lord, kindly comes to my prayer, I have taken that plea in respect of only the subsequent brochure where they have specifically mentioned, my lord, that the only government employees of exclusively for the government of West Bengal. That particular advertisement I have challenged. And another reason is also
How
there,
two cause of action can be joined together?
Yes, my lord. Yes, that is the reason, my lord. I am coming to that point. What happened, my lord, when this matter was first taken up before the coordinate bench?
No, I know, I'll not hear that.
No.
I'm not. Don't embarrass this court. Just you have to satisfy me.
That is, I am not taking anything
So
out
the
of
pleading, I don't know. Object.
My lord, they gave an undertaking that they are not creating a third party interest. That is part of our pleading, my lord. They took a undertaking that they are not creating a third party interest. Very well, my lord. Though no, that has no reflection in the order, but we go by our, my lord, gentleman words. Now, my lord, they have filed that this thing report on affidavit. They have nowhere mentioned, my lord, that my plot, that particular plot of land that was allotted, rather I should say allotted to the lottery. What is the status of that land? They have nowhere mentioned. Now, when I took
is there.
no intimation is there. Now, when I took information, then I find, my lord, by way of the second
That has been
advertisement.
included in the second advertisement.
Yes, including the second advertisement, they perhaps they have been already, my lord, allotted in somebody's paper. I do not know the name; those information are not. So, if that is so, my lord, I have to challenge that advertisement. That is the cause of action, my lord.
That is a separate writ proceeding, no?
My lord, in the same writ petition, my lord, I have taken with the joinder of cause of action, my lord.
Very good.
With that as a member. So, my lord, so far the different reasonable that my lord classification is concerned, my lord, that has to be that reasonable classification is to be based upon intelligible differential, and not only that, that intelligible twin test. One test, first test is my lord, intelligible differential. Second test is my lord, that intelligible differential has to be a reasonable nexus with the object sought to be achieved. And perhaps my case will lie upon the second part of this the reasonable classification. What is the object of the HITCO is trying to achieve by way of this the advertisement? When I go through the website of HITCO, I did not find anything, any particular part where the object of the HITCO has been mentioned. But if their introductory part is taken into account, that has been mentioned. I have already made part of my pleading as well as in my affidavit in reply. It has simply means it is one of the government bodies of functionaries of the state of West Bengal. They are developing that particular land. Lot of the IT sectors are coming up. Lot of developments are going on. They are putting the LED light. They are making various parks and everything. No had mentioned they have particular scheme in their in their mindset or in their I should say they are in any part of their administrative function. They have particular scheme in mind that they will develop a particular plot, particular area exclusively for the purpose of the government employees. What is the object, my lord? Once, my lord, I have to, when I am challenging a particular part, my lord, whether it is hit by 14 or not, we have to see what is that object that is trying to achieve that object, my lord. Nowhere there has been mentioned, my lord, that particular land is primarily getting development, keeping primary focus upon the the government employees of West Bengal, or particular one part of the of a my lord employees or my lord this thing. And my lord,
so far Article 14 is concerned. So far, I have read. Article 14 says about the equality before the law and equal protection of law. Am I correct, sir?
Yes.
There cannot be any application of Article 14 if there is a classification between equal and unequals. But if there is a classification between the equals, it will hit by under Article 14. So, according to you, there was by the act of the respondent authorities, HITCO, is such that there is a classification between the equals. So, how you come under the clause of equality within the meaning of Article 14?
Because, my lord, they have making this particular, my lord, the lottery or the allotment of this exclusively for the government employees of West Bengal. That they cannot do. This particular HITCO is not primarily meant for government employees of West Bengal. They have nowhere they have mentioned. That is a twin test, my lord. Whether intelligible definite, because reasonable classification is an exception to Article 14, my lord. Equality is there, and reasonable classification, they pass the test of reasonable classification, my lord. Certainly, my lord,
then the question arises, why you have not come earlier?
Well, I have
challenged. No, latches and delay is a good ground for refusal.
There is no latches, my lord. There are no latches. I was informed of my outcome of my application only during the course of my lord the previous writ petition. The previous writ petition was filed primarily for the purpose of knowing what is the status of my application. They did not, it is nobody's case. They have nowhere taken this plea. No, I had informed you, but you were sitting tight over the matter, or you were keeping silent. It is nobody's case, my lord. In the previous writ petition, when I filed about
in the event the HITCO publishes an advertisement for allotment of a portions of the project for
exclusively for government of West Bengal or instrumentality of government of West
Bengal. What is the unreasonableness?
Unreasonableness is, my lord, that is not the object of HITCO, my lord. That they will reserve particular plot of land only for the particular category of people. That is not the object, my
lord. They cannot categorize the plot of land as an LIG, MIG or HIG also.
That is based on income. Income tax is there, my lord. Income tax is not hit by, my lord, reasonable classification. That is why, my lord, the particular employee under particular bracket of income is paying higher taxes, and another person coming under lesser income is paying lesser income. Income tax is not coming under my reasonable classification. Rather, it is coming under reasonable classification test. And, my lord, another point, my learned senior friend too, perhaps we both of us already opened our cards. In the previous occasion, my lord, I do not know whether my lord Cecil will take that point or not. Be that as it may, my lord, it was, my lord, it was argued that since the type 2, my lord, the plot of land was was open for my lord general public, so therefore my lord reasonable classification is not fit. Because type 1 is there, that was their my lord their submission. That type 1 was meant for government of West Bengal employees and type 2 was for common people. So therefore I could have easily applied under type 2. My lord, that is not the case. If my lord advertisement, we go through the advertisement, the type 2 is available only when any plot of land remains my lord is unapplied for. For example, there are 400 of plots of land, my lord. If the applicants are more than 400, so all the plots of land will be available for type 1 only, and not a single plot of land will be available for type 2. And in this case also similar thing happened. It is there, my lord, there was no lottery was held for type 2, so that the common or general public would have applied under type 2 category. Because type 2 category is available only when the number of applicants are less than, my lord, the number of plots available for lottery. So therefore, my lord, they cannot save, my lord, only by making this, I should say, frivolous and fallacious this option of type 2, because type 2 is never available. I wonder a single instance may be given by the state or the HITCO that the type 2 was ever available, where the type 2 one was not applied for by the number of plots, rather the applicants were less than the number of plots available. So, my lord, the reasonable classification, again, my lord, I'm coming back to the same my lord, the submission. The reasonable classification, they have to see, my lord, that is a twin test, my lord. Two tests is to be, my lord, applied. I'll cite those decisions, my lord, and how this scheme is in other cases was scrutinized by the court. In some cases, the court found those, my lord, schemes not rather is not hit by this class legislation. So, my lord, not only the intelligible differential, they may have done intelligible differential, so that by way of, my lord, the making the segregation only for the government of West Bengal employees. Yes, that is an identifiable, that is a separate category which can easily be separated from central government of employees. But again, when the intelligible difference is to be created, then the object is to be seen. What is the object? What is the object behind you making the segregation? When you're making the segregation, what was the actual purpose that you're trying to achieve by way of this particular segregation, by depriving a similarly situated person, not applying under this act? I could not find a single, my lord, scrap of paper so far the public information available under the public portal, my lord, that the object of the HITCO was primarily meant for, my lord, the development or for allotment of land for government of West Bengal only, or, my lord, they can particularly make a parcel of particular a portion of the land for exclusively for the purpose of government employee. There is no such scheme, my lord. So far, till this very date, my lord,
in the event the HITCO keeps some plots of land for the government employees, I fail to understand. Maybe on account of my part, that how Article 14 has been violated. That I fail to understand.
Because, my lord, they cannot do. Because that is not the object of HITCO, my lord, to keep particular land for particular category of people. They cannot do, my lord. If government employees, let it be, well, all the government employees. Had it been all the state government or central government, the Article 40 would not have been applied, my lord. This particular act could not have been hit by the Article 40. So what, my lord, punishment, what the offense, my lord, the central government employees have done? They are also serving in the state. They are also serving the people of West Bengal. What is, there must be some reason, my lord. When a scheme comes there, that is why, my lord, the schemes come, there has to be objective, and that is why, my lord, the judicial review is there, my lord, on Article 226 and 32. Otherwise, every action of
you could have not come.
Because I was eligible.
You have come only
Yes,
after rejection
yes,
of your application.
my lord. Yes, why I have not, perhaps I can answer, my lord. Why I have not challenged this particular book? Because I am coming under the statutory bodies in West Bengal, my lord. In plain and simple reading of this line,
So
my lord,
even we have applied as an employee or in the payroll, you are in the payroll of the employees of the central government undertaking. Still, then you have not felt that it is an unreasonable classification.
because all the government employees can apply, then it is not unreasonable classification. So all the government employees cast. There are two types of government employees: state government employees and central government employees. So there is no such hindrance. Because central government, because government of Odisha cannot have an office in West Bengal unless one particular project is taken up by the government.
No,
So central government,
if I accept your contention, let us once again come to page number 40, sir. All West Bengal government employees, including police, then all central government employees, including the central government police, CRPF. Why not that is there? It is an unreasonable classification against.
This means police, whatever the under the definition of police,
You are employees of the statutory bodies of the West Bengal. Then why the employees of the central government or Union of India?
Statutory bodies in West Bengal, my lord. It is mentioned in West. Had it been an of West Bengal, my lord, they would put.
No, I am on clause 1. All West Bengal government employees, including police,
Yes, my lord.
and
Thereif
then if they accept your condition, all government employees of the Union of India. It should have been.
That they did not mention. Once the central government means the Union of India, my lord. Central government India means Union of India, in my understanding.
So Article 14 arises, so far my knowledge goes, if there is inequality amongst equals. How you come under the purview of the equals? That I
because they are government employees, my lord, kindly consider. They have mentioned government employees, and I am saying it is government of employee means all the government employees, state government employees and central government employees.
In the event the persons standing in equal 14 have been differentiated, Article 14 has come to rule.
They have mentioned government employee. Now they are saying government employee. No, not government employee. West Bengal government employee. That is the, my lord, Article 14 is it.
Very good.
Government employees, my lord. They have mentioned government employee. And when they are defining.
Very good. I understand your contention. Anything more, sir?
No, not anything more, my lord. And so far, I'll cite the decision before the decisions are cited, my lord. May I just show their so-called letter once? Because in the so-called letter, my lord, they have mentioned eligibility. That you are not eligible under this particular advertisement because you're central government employee. And when they are rejected my application, they have relied upon article clause 12, my lord. Kindly see the order of rejection once, page number 115.
Yes.
Second paragraph.
As per clause 12.
Yes, as per clause 12, my lord. And if my lord, kindly see one, their so-called letter once, my lord, kindly see once.
It has been found that all the members of your cooperatives are central government employees.
And the proposed FCI employees cooperative society is not eligible to be type 1. So no my lord, clause has been mentioned. Okay, that is, I am not saying they should have rather mentioned the clause. That is not the point, my lord. Even without referring to the particular clause, they could have easily rightfully issued a so-called notice. That is another issue. But so far the eligibility part is concerned.
What is the so-called notice, sir?
So-called notice 85, my lord.
Page number 85. Give me a second. Give me a second, sir. Give me a second. Yes, sir. So-called notice.
They have not mentioned in that very words, my lord. But what I can find, that is the nature of the proposal. Paragraph number 13, my lord, they have mentioned.
No, it is their consistent stand. Come to paragraph number 3.
Yes.
Third line.
Yes.
As all the members of your proposal are central government employees.
That is the ground they have taken. And now, my lord, while cancelling, my lord, they have relied upon article clause 14, my lord, clause 12, my lord. So kindly see the clause 12 once, my lord. The central government or state government, my lord, they have nowhere mentioned, so they cannot take that plea. So they have taken that clause number 12. So I'm just trying to understand, my lord, whether this clause is applicable in this case or not. Page number 38. WB HITCO will conduct verification of the application and can reject application for factual error, my lord. Factual error. I have not committed any error, my lord, whether it is fact or law. We are the employed, we applied under, my lord, the particular, what of thereafter, my lord, kindly see one. May I read that particular, whether it is applied or not. It is factual error or submission of wrong. It is, my lord, we have not submitted any wrong application, my lord. It is not that we have wrong application you have filed. Whatever the information available with us, we have applied. And incomplete supporting documents. All the supporting documents, complete form we have given. And information. The applicant will need to ensure the correctness of the application. We have ensured the correctness. It is not that it is a wrong application or wrong information we have given, or we have given any factual erroneous representation or facts. Whatever the facts available with us so far, our eligibility is concerned, we have given. So in my humble submission, my lord, this clause 12, if we read in its proper perspective, it is not applicable in this case. Fact, neither it is a case of factual error, nor it is a case of submission of any wrong or incomplete supporting documents, nor it is a case of, my lord, the not ensuring correctness of the application. So for clause 12 is concerned. Though they have taken, my lord, plea that, my lord, central and state government, but since it is nowhere mentioned, so that is why they could not, my lord, rely upon any particular part except this one. And in my humble submission, my lord, this particular clause is not applicable to. I have not given any. My lord, since, my lord, they have taken in their report on affidavit, my lord, the point of necessary society, because they are trying to show, my lord has also gone through that part, my lord, employees of. It is true, my lord, except that particular line, all other lines are referring to government of West Bengal. Admitted case. I cannot improve upon the facts, my lord. But since that particular line is clear and, my lord, there is no ambiguity in this case, my lord. So therefore, my lord, that particular principle of necessary society will not apply. My lord is aware of that the law of interpretation of, my lord, this statute of the word comes into play only when there is an ambiguity of a meaning. If the meaning or understanding of a particular word or phrase is clear and unambiguous, my lord, then the law of interpretation will have no role to play. I'll cite only two decisions to counter their point of, my lord, necessary society. One case was, my lord, previously also, my lord, submitted, perhaps they have taken note of it.
It is there in the file.
Pradeep, for ready reference, my lord, I am giving another one. Pradeep Agarbatti, my lord, Pradeep Agarbatti. Pradeep Agarbatti.
No, in the file there is a judgment of Supreme today.
Supreme today only. Anyway, I am giving another one. Copy may I give? Decision, my lord. There is similarity between this issue and this particular decision, my lord. That is why, my lord, I tried to, my lord, this project their subsequent advertisement, because the first advertisement, my lord, they have not mentioned exclusively government of West Bengal employees. Subsequent they have mentioned. In this particular case, it was an excise case, though. My lord, the question was whether, my lord, the agarbatti or the incense sticks will come under the particular phrase perfumery. So article, if kindly comes to, my lord, 3-page edition, kindly come to page number 2, my lord. Paragraph number 2. The appellant is a registered dealer in Dhoop and
Give me a second, sir. Paragraph number?
Paragraph number 2, madam.
2. Yes.
Appellant is a registered dealer in Dhoop and Agarbatti and we are concerned with the assessment to sales tax thereon under the provision of Punjab Single Sales Tax such and such for the period such and such. Entry number 16 of Schedule A of the said Act at the relevant time reads thus: cosmetic, perfumery, and toilet goods excluding toothpaste, tooth powder, kumkum, and soap. The said entry number 16 was broken into entry number 16 and 16A by notification dated 1979. The new entry reads thus: cosmetic and toilet goods excluding toothpaste, tooth powder, kumkum, and soap, perfumery including dhoop and agarbatti. So, my lord, initially, dhoop and agarbatti, there was no mentioning. Only perfumery, and what are the including things that they have mentioned and what are the excluding things that they have mentioned. Subsequently, my lord, they came out another notification and now they simplified the thing, rather clarified the thing that perfumery including dhoop and agarbatti. So this particular appellant case was this. My lord, they took tax upon the dhoop and agarbatti because they were charging that dhoop and agarbatti under the perfumery. That subsequently, this, my lord, the perfumery were defined including dhoop and agarbatti indeed, but at the relevant point of time, my lord, the perfumery was not defined to include dhoop and agarbatti. The Supreme Court applied the principle adjudicative generis and society nosaesis and says कि since that particular meaning nowhere means dhoop and agarbatti, and that is further clarified because when they subsequently came with another notification clarifying this particular point, so therefore, my lord, the perfumery would not include dhoop and agarbatti. If my lord desire, then I can read, my lord, those paragraphs.
Kindly read. Which paragraph?
My lord, 6, my lord. Paragraph number 4 and 4, 6, my lord.
Kindly place.
The appellant was sought to be made liable to pay sales tax at the rate of 10 paisa in a rupee, as was leviable upon times falling under the said entry number 16 on the basis of that dhoop and agarbatti was covered by the word perfumery. Therein, the writ petition filed by the appellant there against was allowed by the learned single judge who placed reliance upon the context in which what perfumery was used in the entry number 16. The division bench in appeal reversed the learned single judge primarily rely upon the judgment of court in commission number such and such on reasonable mention. Therefore, my kindly comes to paragraph number 6. Learned counsel for the appellant commended for acceptance by reasoning of a division bench of High Court at Bombay in the judgment in Commissioner of Sales Tax Maharashtra State Bombay versus Gordhana Torkisi 2. The question here was whether sandalwood and sandalwood oil was perfume that fell within the entry of perfumes and depilatories and cosmetics. Thereafter, my lord, those nitty-gritty has been mentioned. Kindly comes after few lines. Applying this rule of Nosaicide Society, the word perfume in the entry was to be understood in conjunction with cosmetics and depilatory. In other words, the word perfumes referred only to such support from the judgment in Madras High Court.
No, you have missed a line.
Oh, I'm sorry.
Only to such preparations.
Preparation as were commonly known in the market for use on the human body as perfumes. The Bombay High Court gives support from the judgment of the Madras High Court in such and such, where a similar view has been taken. The Bombay High Court also drew support from the case of assessing authority versus such and such, in which the Punjab and Haryana High Court has earlier construed the very same entry number 16, which is now before us, and held that dhoop and agarbatti could not be held to be perfumery within the meaning of that entry. The Bombay High Court distinguished the judgment of this court in Indian Herb Research and Supply Company by noting that this court was not there required to consider the term scent and perfume in conjunction with articles of toilet or cosmetic. The words stood by themselves and there was no reason to limit them in any manner. Thereafter, my lord, this paragraph number 7 and 8 was dealing with those earlier decision, my lord, that need not be gone through. Kindly come to paragraph number 10. We are in no doubt whatever that the word perfumery in the said entry number 16 draws color from the words cosmetic and toilet goods therein, and that so read the word perfumery in the said entry number 16 can only refer to such articles of perfumery as are used as cosmetic and toilet goods upon their person. The word perfumery in the context in which it is used has therefore no application to dhoop and agarbatti. So court came to a finding that the word perfumery does not apply to dhoop and agarbatti, which, my lord, they subsequently included under perfumery under my lord notification 16A, perfumery including dhoop and agarbatti. In my understanding, in a similar fashion.
How this case is relevant to your case?
Yes, my lord. So far, the statutory bodies in West Bengal is concerned. I will take that, my lord, particular line in my understanding. I am a layman. I have seen any person can go through the statutory bodies in West Bengal. I am the employee of a statutory body. I have formed a my lord, cooperative society and the cooperative society, and my employees also is in West Bengal. I have applied. I am nowhere.
You are not the employees of the statutory bodies. You are the employees of a body corporate under the Union of India. How is it statutory bodies?
Well, it is a statute. It has came into existence by a statute, my lord. Food corporation.
It is a body corporate.
It is a my lord, Food Corporation Act is there, my lord. Only by the statute, my
very
lord,
good.
it came into existence.
For the sake of argument, if I accept, you have to decide whether you come under the zone of the government employees or not.
My lord. Because
That's all?
statutory bodies or not, my lord. Now, my lord, in another case, my lord, I will refer another 3 decisions.
Yes, refer, please refer.
So far the society necessity again is concerned, my lord, that is slightly in a different context, but the rule is, in my understanding, applicable here. That in arbitration case, my lord, whether my lord interest would be payable if the parties entered into an agreement debarring themselves from getting any interest. My lord, in previous Act 1940 Act, my lord, those provision was missing. After the 1996 Act, my lord, that particular provision has come at section 31(7)(a), my lord, whereby, my lord, the party can agreement or the contract out of getting interest. If they make a contract, they will not claim any interest. The arbitrator cannot grant any interest. Now, my lord, the clause was this, my lord, similar like this, that the no amount was payable, no interest would be payable under security deposit, my lord, the performance guarantee or any other sum payable to the contractor under the contract. This was the particular clause. The Supreme Court referred to various other full bench decisions and come to a particular finding. So, my lord, the particular clause was this, like, my lord, if I repeat, that the no interest would be payable under security deposit, performance guarantee or any other sum due to the contractor under the contract. Now,
But we will get these lines.
my lord, this is there, my lord.
This is?
My lord, this particular decision, my lord.
Oh, I see.
Before going through, I'm just, my lord, giving a summary.
Achha,
of the issue. So, this particular line was under the consideration of the Supreme Court, whether by way of that particular clause, this arbitrator is debarred from granting interest in respect of other claims. It is quite, my lord, evident that security deposit, I am not entitled to get interest. Performance guarantee, I am not entitled to get interest. But whether so for the other claims, there are several tens of other claims may be there. Whether interest can be payable under those claims or not. Now, the necessary societies was, my lord, taken a plea to oust this particular claim. Because, my lord, this particular word or any other sums due to the contractor under the contract was also not payable. So, it is followed by, my lord, those previous words, security deposit and, my lord, the performance guarantee. So, they says ki all this particular word is to be read only those claims which is relating to the security deposit and performance guarantee. But Supreme Court says no, it is not like this. Only because the necessary society adjudicative generis you are applying, that cannot be applied in this case. Here, this meaning is simple and clear that no other sum payable to the contractor under the contractor is payable. Interest under the in respect of any other claim payable to the contractor and the contract is payable.
How it is relevant in the facts of the
because, my lord, they are relying upon, because the statutory bodies in West Bengal and all other subsequent terms relating to government of West Bengal employees. So that is why they are harping on that particular clause. Statutory bodies in West Bengal means statutory bodies of West Bengal, government of West Bengal. That is the plea, my lord. They have so far their report on affidavit is concerned. They have taken this specific plea, my lord. And Paras, my lord, is also, my lord, is so far the plain meaning is appearing to be like this only. Statutory body is West Bengal, it is followed by police, teaching staff, non-teaching staff, panchayat. So it should be meant as a statutory bodies of government of West Bengal. So there also, my lord, that particular word was followed by the word security deposit and performance guarantee. But Supreme Court did not buy, my lord. May I read, my lord, few of those paragraphs?
Yes.
জানেন ওই মিনরাজ কনস্ট্রাকশন, মিনরাজ এন্টারপ্রাইজ, ওই ইন্টারেস্ট নিয়ে তো first I read, my lord, that paragraph number 3.
What is the citation?
Oh, I'm sorry, my lord. I've given.
এই দিয়েছো?
Two 2022, volume 2, SCC 331. If, my lord, kindly comes to page number 4, paragraph number 3.3.
Para
3.3. Page number 4, my lord.
Yes.
It is further submitted that the power of arbitrator to award pendentility interest considering perimeter clause to clause number 16 of GCC has been examined by the 3-judge bench of this court in the case of Union of India versus Bright Power Projects. It has been specifically observed and held in the said case that in view of the specific contract between the parties and the bar of awarding interest, the payment of interest was not permissible even on earnest money deposit and security deposit or amounts payable to the contractor under the contract. It is submitted that the expression amount payable to the contractor under the contract is wide enough to cover every payment of amount payable under the contract. That was the plea taken by the one of the parties to my lord the claim of the other part contractor to claim interest, and it was established, my lord. Now, if my lord kindly see that particular clause that is there in page number my lord 8.
6.3.
Yes, my 6.2, my lord, 6, page number 8, my lord. And 6 before that, my lord, subpara 2, it is actually 16.2. Second paragraph on top, page number 8.
Very good.
No interest will be payable upon the earnest money or the security deposit or the amounts payable to the contractor under the contract. This was one of the particular clause that was under discussion before the Supreme Court. Now, if we go particular these two lines, it appears, my lord, the no interest will be payable upon the earnest money very well, upon the security deposit very well, and amounts payable to the contractor under the contractor. The plea was taken, this other amounts payable to the contractor under the contract is to be meant only those claims which are related to earnest money and security deposit, like in our case, my lord. Statutory bodies in West Bengal, since subsequent were also only meaning, my lord, the government of West Bengal, so therefore, my lord, the statutory body.
The amounts payable to the contractor under the contract means the relevant contract or any other contract?
It is contract only, but the plea was, it was pleaded before the court that the other amounts payable to the contractor under the contract is to be limited only to earnest money, relating to earnest money and security deposit, because it is followed by these words. No interest is payable upon the earnest money or the security deposit or amounts payable to the contractor under the contractor. But the Supreme Court did not take this plea. It says that only because it is followed by earnest money and security deposit doesn't mean the other claims would be relating to that particular claim. Any other claim which is otherwise permissible, in those claims, my lord, no interest to be payable. And those findings are there, my lord. I am coming to those relevant paragraphs. Why I am, my lord, relying upon this particular part, because in my understanding they have taken a similar point. Paragraph number 10. From paragraph number 10, my lord, the court has page number 12, my lord. The further submission made on behalf of the respondent is that the clause 16 has to be read as a whole, and on doing so, it can be said that the clause 16 pertains to specifically earnest money and security deposit, and that the same can in no way be read in a manner to imply a bar on pendentility interest. It was the defense that they take, which was ultimately rejected. It is required to be noted that clause 16.1 with respect to earnest money and security deposit, however, clause 16.2 specifically with respect to interest payable upon the earnest money or the security deposit or amounts payable to the contractor under the contract. The words used or therefore the expression amounts payable to the contractor under the contract cannot be read in conjunction with earnest money deposit or security deposit by applying the principle of adjudicatum generis. The expression amounts payable to the contractor under the contract has to be read independently and disjunctively to earnest money deposit and security deposit at the word or and not and between earnest money deposit and security deposit, and amounts payable to the contractor under the contract. Therefore, the principle of adjudicatum generis is not applicable in the present case. On the principle of adjudicatum generis, the court in the case of such and such, thereafter, my lord, the court has relied upon other decision which were, my lord, full bench decision, like the diet of development is also full court decision, my lord, full bench decision, my lord. Thereafter, my lord, the Garg builder decision was also relied upon. I am not going through the similar principle. So, in this case also, my lord, this particular line is to be taken in isolation from which the other lines are mentioning. The plain and simple meaning or reading of that word is the statutory bodies in West Bengal. If my humble submission, if I am a member of statutory body in West Bengal, then I can eligible. I can apply and rightly apply, and I'm eligible to get allotment of this.
Very.
And my lord, so far reasonable classification part is concerned, my lord, I will cite only 3 decisions, my lord. One previously already cited, my lord. I do not know it is available in the record or not, but I have a ready.
1981, volume 2, SC 270.
Nakara, my lord, DS Nakara.
On Kumar Sharma.
For my learned senior friend may have cited, my lord.
No, it is for the petitioner.
Well, it is there, my lord. I have brought another copy.
DS Nakara is there. DS Nakara versus Union of India.
My learned senior friend is some.
My lord, if my learned friend concludes today, my lord, I think he will cite 2 or 3 authorities more.
No, those are available in the file.
Yes.
It was previously referred.
Yes, previously. DS Nakara, one some Sud or something like that.
DS Nakara.
Om Prakash Sud and Mahavir Auto.
Those 3 are there. Om Prakash, yes, Om Prakash Sud is also there.
Yes, these are the 3.
One new decision I'll cite today. My senior friend is already aware of those decisions. Another decision I will cite today. But since my lord,
apart from these 3, you will rely on another decision.
My lord, even though those copies are before your lordship, but I have not, I had no privilege to submit those decisions before your lordship. So kindly allow.
Who are restricting you?
Should I give another copy or it is there?
No, it is there.
Well, shall my learned friend conclude today? I give my reply tomorrow, subject to your lordship's kind consideration.
Why, sir?
Only reason may I be very candid to your lordship. My lord, there are matters posted at 3 p.m. So,
Mr. Mujumdar, difficulty is with me that I do not keep any matter part heart, usually.
very well, my lord. Let him conclude. I am here.
Yes. It is beyond my practice. I have so far.
We will do that. We will do that. No
Yes, sir.
convenience of
I have another urgent matter. Yes. The urgent matter I may not take. Yes. Except one matter of Justice Chatterjee's court. That I will take. Yes, sir. Please.
Sorry, my lord, only 3 paragraphs I will refer to. These are very celebrated decision my lord is aware of, but nevertheless, my lord.
Apart from these 2 paragraphs, these 3 decisions.
My lord, paragraph 10, my lord, page 3. Nakara.
Nakara. Give me a second. That is reported in 1983, volume 1, SC 305.
Yes, my lord.
আপনার 10 মিনিট তো লাগবে
হ্যাঁ
মানে can I come back in 5 minutes my lord?
Yes, sir, that you can.
Yes, I come back in 5-10 minutes.
305 para
10, my lord.
para 10.
The scope, content and meaning article 14 of the constitution has been subject matter of intensive examination.
Yes.
As is quoted in a category of decision, it would therefore be merely adding to the length of the judgment to recapitulate all those decisions, and it is better to avoid that exercise, save and except referring to the latest decision in subject of Manika Gandhi, President of India. Thereafter, under inverted comma, what is the content and reach of the great equalizing principle enunciated in this article? There can be no doubt that a founding faith of the Constitution, it is indeed the pillar on which rests securely the foundation of our democratic republic, and therefore it must not be subjected to a narrow, pedantic and lexicographic approach. No attempt should be made to truncate in all embracing scope and meaning for, and to do so to violate the activist magnitude. Equality is a dynamic concept with many aspects of dimension. It cannot be imprisoned with traditional and doctrinaire limits. Article 14 strikes at the arbitrariness in state action and ensures fairness and equality of treatment. The principle of reasonableness, which legally as well as philosophically is an essential element of equality or non-arbitrariness, pervades Article 14 like a routine of the pages. The decision clearly lays down that Article 14 forbids class legislation. It does not forbid reasonable classification for the purpose of legislation. In order, however, to pass the test of permissible classification, two conditions must be fulfilled. First, that the classification must be founded on an intelligible differential which distinguishes persons or things that are grouped together from those that are left out of the group. Very well, my lord. They passes the first test, my lord, because central government employees can be easily differentiable. There are second clause, my lord, that the differential must have a rational relation to the object sought to be achieved by the statute in question, my lord. This is the, my lord, the part which, my lord, is impinged by the actions of this writ court. They cannot show a single part wherefrom they can show this is their objective that they try to achieve by of allotting a particular plot of land only for the exclusively reserved for the government of employee. They may, my lord, but there has to be certain scheme. I'll cite the recent decision of Supreme Court where, my lord, the various scheme, welfare scheme at the time of, my lord, election. My lord is aware of South India, my lord, during election, various welfare schemes are is public, like freebies, giving freebies like TV, my lord, laptop are there, my lord. So there also Supreme Court came to scrutinize one particular scheme. There was certain scheme was there, my lord. In each and every aspect, my lord, the why particular group of people were taken into account and why the other group were not taken into account, it was specifically mentioned there, my lord. I failed to understand, my lord. I could not find a single paper where I can at least satisfy myself that they passed this test, my lord. That it was their objective, my lord. They can certainly do, my lord. I am not agitating that they cannot do, but there has to be certain scheme. Otherwise, my lord, this particular act will come under the definition of arbitrariness. Because they suddenly they would want find money, they would decide, okay, I'll only allot the land only for exclusively for the state government. Because central government employees are not, my lord, outcast. They are also serving there. They are also equally, my lord, placed only because there is a federalism in our state. Two governments are there. So that doesn't mean, my lord, the one particular government employees to be ousted. If that is to be ousted, there has to be certain scheme, my lord. There's no scheme in this particular, at least in this particular case, is, my lord, missing. And my case is wholly, my lord, is founded upon that principle. It is a violation of second, my lord, test, that is the differentia must have a, it is a differentia, I admit, my lord, they have reasonably, my lord, they intelligibly differentiated between two groups. But that the differentia must have a rational relation to the object sought to be achieved by the statute in question, it is missing in this case, my lord. The classification may be founded on differential basis according to the objects sought to be achieved, but what is implicit in that there ought to be a nexus, that is a causal connection between the basis of classification and object of the statute under consideration. It is equally well settled by the decisions of this court that Article 14 condemns discrimination not only by substantive law but also by a law procedure. My lord, I could not find that HITCO was again, my lord, at the cost of repetition, I may submit, my lord. The HITCO was found primarily for the purpose of developing a particular government employees, my lord. It is a state largesse. Kindly appreciate another aspect, my lord. The allotment of why there is a crisis of land, my lord. Because the land prices are very high. People are many, lands are, my lord, few. So once their prime lands are available, my lord, and those are also available on a very reasonable price, that is why lottery is there, my lord. So that is state large, it's a state grant, my lord. So when the state is making certain grant, making a charity, I should say, or exercising its duty in course of their welfare activities, my lord, there has to be certain scheme, my lord. This is the objective. In achievement of in achieving that particular objective, I am reserving this particular plot area of land for particular category of people. My lord, kindly comes to thereafter, my lord. Paragraph 7. The classification must not be arbitrary and must be rational. That is to say, it must not only be based on some qualities or characteristics which are to be found in all persons grouped together and not in others who are left out, but those qualities or characteristics must have a reasonable relation to the object of the legislation.
I understand you. Next.
Yes, my lord. I am not reading other paragraph. My lord can take note of, my lord, I will rely paragraph number thereafter 7 and 13, my lord.
7 and 13.
13
Yes.
Thereafter 15 up to 16, my lord, page number 5. Except the last line up to page number, my lord, 5.
Yes.
Thereafter, my lord, the second decision, previously I did not cite, my lord. At that time I was not.
Oh. Without.
Taking 2021, volume 15, SCC 534.
What is the citation?
2021, volume 15, SCC 534.
I repeat, 2021, volume 15, SCC 534.
534, my lord.
Paragraph?
Sorry, my lord.
Paragraph?
Paragraph number, paragraph 12, then from 14 to 30.
Paragraph 12, then?
Paragraph 2.
Oh, 2, I'm sorry.
Thereafter 14 to 31.
Give me a second. Paragraph 2, Thereafter
14 to
14 to
31. Mala, this was the appeal preferred by the state of Tamil Nadu because Mala, the state of Tamil Nadu came out. They were giving certain waiver of loan for a particular agricultural Mala farmers. So this particular scheme, so far the waiver of loan is concerned, my lord, government loan. So they were giving waiver of loan only to a particular farmers who are having a particular quantity of land. So that particular scheme was challenged before the Supreme Court because it was the plea taken by why the larger, the other farmers who are having a larger quantity of land, while they would be deprived of getting a similar benefit of waiver of loan when there is a, my lord, the drought and other calamities are there, my lord. And it was also my lord, pleaded that since the larger quantity of landholder contributing more in terms of revenue to the government, so they should equally be, my lord, coming under this scheme. So thereafter, my lord, this scheme was, my lord, scrutinized by the Supreme Court. And why I am saying so, my lord, if my lord kindly sees from paragraph number 14 at page number 6.
yes, sir.
I'll read few paragraphs and then I'll show, my lord, how this came into finding. The Equality Code in Article 14 of the Indian Constitution prescribes substantive and not formal equality. It is now well settled position that classification per se is not discriminatory and violative Article 14. Article 14 only forbids class legislation and not reasonable classification. The classification is reasonable when the twin test laid down by Justice S.R. Das in state of West Bengal versus Anwar Ali Sarkar are fulfilled. Again, my lord, repeated, the classification must be based on intelligible differentia which distinguishes persons or things that are grouped from others left out of the group. Second, my lord, the differential.
Same.
Yes, my lord. Thereafter, my lord, the other decision was referred to, and thereafter, my lord, I am not referring to those decisions. And kindly see, my lord, thereafter the scheme was put before the Honorable High Court. My lord, paragraph number 22, 23 was already referring to those reports. Before this came in, my lord, the scheme was, my lord, floated. The reports were also placed before the legislature, and upon the basis of this legislature, the scheme was, my lord, made. Kindly see paragraph number 24. There also why the only marginalized labor, I should say the land, the agricultural farmers were only given this benefit because of the scheme and because of the report, my lord, those are given. Paragraph number 24, 25, then my lord, kindly see 26, my lord. The High Court in the impugned judgment has observed that the scheme is both under-inclusive and over-inclusive since the total extent of land held by a person is calculated based on the information in the landholding register, which permits discrepancy. It was held the scheme to be under-inclusive for not extending the benefit to other farmers or the larger farmers. The meaning and ambit of under-inclusiveness and over-inclusiveness has been discussed in the erudite exposition of Justice K.K. Matthew and writing, because the under my lord inclusiveness and over inclusive also came into discussion before the Honorable Supreme Court. If my lord allows, then I can read that paragraph. 55. A classification is under inclusive when all who are included in the class are tainted with the mischief, but there are others also tainted whom the classification does not include. I am also a government employee, but I am a central government employee, so I am excluded. In other words, a classification is bad as under inclusive when a state benefits or burden persons in a manner that furthers a legitimate purpose, but does not confer the same benefit or place the same burden on others who are similarly situated. I am similarly situated. I am also a government employee. I should not be punished only because my lord.
Very good. Any other point?
Thereafter, my 27, 28, my lord, the similar points are, my lord, discussed, my lord, and up to paragraph number 31, my lord. The scheme was discussed, and my lord, the court, because of the report, because of the scheme, and because of the purpose, where only the small landowners, my lord, the farmers should get the benefit, that was placed for the lordship, which is missing in this case. My lord, another decision.
No, if the same principle is decided, don't pardon me with there is no need actually. If new law is framed or new law has been discussed, I can take it.
In another perspective, I should say, the same law, reasonable classification is well settled, my lord.
That's all, sir.
For my sake, my lord, if kindly keep this record on.
No, sir, if it is on the same principle, I don't know why you are pardoning the court on this.
I'm sorry, my lord. Paragraph number 3. Very well, my lord.
Any other points, sir?
Just a second, my lord. Another decision was there that is against the Mohabir Auto, previously I cited against the India law.
Yes.
There also, my lord, the government in an arbitrary manner, my lord, refused to enter into the contract.
Give me a second, sir. This is 1990 volume 3 SCC 752, no?
Yes, my lord, 752. Paragraph number, my lord, can note 12.
Just a minute, sir. 1993 volume 3 SCC 752. Paragraph number?
12 and 13.
Yes.
My lord, should I give copies there, my lord?
It is there. It is there.
So, my lord, this is the.
As a matter of fact, I have gone through these
My lord,
yesterday.
my lord, yes, my lord, I can. Because half of my job has been, my lord, half, and I should say lessened because of the, my lord, the great pains my lord has already taken. And my lord, again, I'll.
No, it will be easier for the court also, no? To understand the case.
Because the
If
result
the
will
court
go
comes
either,
ready, the court comes ready.
result will go either way. But
So that is different.
That is different. My lord, if my lord kindly on that occasion, my lord, previously I was saying that type 2, it was there taken. The type 2 is open for my lord, the general public. So therefore it is not hit by this thing. So may I just show my lord that the type 2 is available only when type 1 is not
Very
exhausted.
good.
Page number
Any other
40
points?
Page number 41, my lord. My lord can take note of it. Paragraph number 41.
Paragraph 41.
41 of the advertisement. I'm sorry, my lord. Page number 41. Page number 41 of the advertisement. My writ petition, I should say. That is a part of the advertisement.
What is that?
That is, my lord, because type 2 is common for common people, my lord.
That you have submitted.
Yes, that particular clause is there. But I have submitted, but I have not taken. I did not take your lordship through those, my lord, relevant clauses.
Page 41.
Page 41
of the writ petition.
of the writ petition.
What does it say?
Case number 1, case number 2 is there, my lord, in bold letters. If under the case number 1, if my lord kindly come to the third paragraph. After completion of lottery of type 1 societies.
I'm sorry. I'm just a minute. Yes.
Under case 1, third paragraph. After completion of lottery for type 1 society, further lottery will be held for the residual plots among the type 2 housing cooperative societies. And thereafter, my lord, kindly comes to the last paragraph. In case there will be lottery for the selection
I'm
of
sorry,
type.
sir. Page number 41. Which portion you are referring?
My lord, there is a one bold letter. Case 1 has been mentioned.
Case 1, yes.
So under case 1, third line, my lord, third paragraph, I should say.
Third line, yes.
After completion of lottery for type 1 societies, further lottery will be held for the residual plots among the type 2 housing cooperative society. So if any property is left after the type 1 lottery, then only it will be available for type 2. That is meant for common people.
After completion of type 1.
How was for type 1? If my lord kindly comes to the last paragraph of the same page. In this case, there will be lottery for the selection of type 1 cooperative society against the total number of plots available for activity. It may be noted here that plots for type 1 applicants are not guaranteed. There shall be no lottery of type 2 housing cooperative society. And in this case also, my lord, indeed there was no lottery for type 2. That would be evident from page number 64. My lord, kindly keep 64 once of the writ petition.
64.
Yes. Type 1, my lord, has been mentioned HIG, MIG, MIG1, MIG2. Thereafter, type 2, if my lord kindly comes to the type 2, again the type 2 remarks, there will be no lottery under this category as the number of type 1 applicants cooperative society is more than the number of available plots of land or process and rules of lottery in procedure. So, my lord, that is a very empty, my lord, I should say consolation to show, my lord, that the reasonable classification is not here. Because hardly plots are available for common people. In all literal sense, they are reserving this land only for the government of West Bengal without any object to show, my lord, that that was the scheme, that was the purpose to particularly develop a particular part of their HITCO land only for the purpose of, my lord, the government employees of West Bengal. So that is, my lord, sum and substance of it. I am deeply of that.
Yes, Mr. Mujumdar.
Yes, ma'am. Well, first kind of made, if your lordship, the writ petition. I will be brief and precise as far as possible. Well, kindly take paragraph 7 of the writ petition. Page 7, paragraph 7.
Yes, sir.
Well, I will be as fast as possible. Well, that the petitioners state that they are all employees of various statutory organizations. Well, may I make it very clear as an officer of the court? So far as the employees of FCI are concerned, well, FCI is a statutory body. It's a statutory corporation. It has been formed under the FCI Act. There is no cavil to that proposition. Like my lord, LIC employees, FCI is like on that. Now, my lord, this is very interesting. There are 8 members. Your lordship will find. Kindly take pages 7 and 8. There are 8 members.
From Abhishek to Aradhana.
Aradhana. Now, if your lordship kindly take 7 and 8. They are not employees of any statutory undertaking. Indisputably. One is an employee working as airworthiness officer in the office of Deputy Directorate General of Civil Aviation. That's Government of India. Well, I will show their pay slips which have been annexed to the writ petition. Number 2, that is Roman 8, or Aradhana Pandey, that is Welfare Administrator in Labor Welfare Organization, Government of India. So this is the. Now kindly take along with this pages 56 and 57. In fact, my lord, this applicant number 8 is not even the petitioner before lordship.
Page number 58.
56 and 57.
Oh, 56 and 57.
57. Your lordship will find 56 is the payslip of Aradhana Pandey. This is Ministry of Labor. So, my lord, this lady is holding a civil post within the meaning of Article 309 of the Constitution. Is a central government employee, not an employee of any statutory body. This is why, my lord, to the best of my understanding, the scope of the challenge has sought to be widened in this writ petition. Now, kindly along with that, kindly take page 57.
Yes.
Well, this is the payslip of Amit Kumar, airworthiness officer, again a central government employee. But these facts cannot be disputed. I don't think my learned friend will dispute these facts. However, all along, it is the submission made on behalf of the petitioner that all the members of the proposed cooperative society are employees of statutory bodies. Well, I will come to in West Bengal, of West Bengal, I will address that later. Now, well, kindly along with that, take, my lord, the Cooperative Societies Act.
So Amit Kumar and Aradhana are the.
So, my lord, we are left with six members who are actually members of FCI.
Yes.
So, out of 8, 2 are central government employees, 6 are, my lord, FCI employees who are statutory. Kindly along with that, read take page 32 of the writ petition. Kindly take clause Roman 6. এটাই তো?
Yes, sir.
Applicant housing cooperative societies belonging to type 1. We are concerned with type 1 only right now. Having gross family income up to 30,000 only per month for each member of the proposed housing society, cooperative society of 8 members. The application itself is deficient because it does not satisfy the requirement of the brochure. As only 6 members, even we take the concept of statutory body, as my lord canvassed on behalf of the petitioner, only 6 members are member of the employees of the statutory body. So out of 8, if it is 6, my lord, it does not even qualify to be a cooperative society as per the West Bengal Cooperative Societies Act. Kindly take, my lord, that is why this provision has been made having regard to section 16 of the Cooperative Societies Act. Kindly take, my lord, section 16.
Subsection 3A proviso.
Proviso to section 16, subsection 3.
Section 16, subsection
3, proviso. Kindly take, my lord, that for your lordship's kind consideration. HIG না MIG? এটা 32 না? না, ওরা কিসে অ্যাপ্লাই করেছে? HIG।
একটু দাও তো, এটা স্লিপ বললেন, স্লিপ দাও।
Maldas got that subject to lordship's. I'm so sorry. I should have waited.
Number of applications should not be less than 8.
Has to be, my lord, because, my lord, only minimum 8 members.
The number of applications shall not be less than 8.
So, my lord, nothing less than 8. At least minimum 8 members are required to form a housing cooperative society or a cooperative society. That is why they pick up 6 from FCI and 2 from central government. They realize this is a colossal mistake, and in this writ petition there is a second round. They challenge this particular brochure as next brochure as discriminatory.
No,
Why?
Here, there are 8 numbers of people are there.
But 2 are central government employees. They are not employees of any statutory body.
That I have understood.
Yes.
Which is why, since it is a housing cooperative,
Right, my lord.
they have 8 persons assembled together.
Absolutely. I bow down.
They form the cooperative society and they have applied. Now your contention is that out of 8, 6 belonging to the statutory body, 2 belong to the central government.
So, my lord, it does
not. They do not come under the criteria
at all. But this is one of my submission. Now, my lord, along with that, kindly now take the eligibility criteria. Your lordship has read it so many times, but for my own satisfaction, my lord, may I take your lordship to this page 40. Then I will come to the other clauses. And I will address your lordship on the judgments cited on behalf of the petitioner too. One more thing, my Mr. Gupta is quite correct in pointing out. Well, your lordship may kindly take page 32 for once again.
3.2.
3.2. The clauses which I was reading.
Yes.
So, my lord, for MIG, your lordship will find Roman 6. For MIG, the income criteria would be is restricted to a cap of rupees 30,000. Your lordship has got that per month. So each of the member, the income of each of the member of the cooperative society shall not exceed 30,000.
Ceiling is 30,000.
Yes. Now for HIG, each member family should have income above 80,000.
Here they have applied for HIG.
Now, my lord, kindly take, it is a strange amalgam which is not permissible. Kindly take, my lord, for once their income, which starts from their pay slip.
They have applied for MIG or HIG?
They applied for HIG. And my lord, your lordship will find
they applied for.
না এটা কি সব কটাই করছো এটা কেন বলছিস এটা সব কটাই করছো
Page 63, page 56.
মানে kindly take again page 56. Your lordship will find, so to apply under the HIG category, income of each member should exceed 80,000. Each member, each family of each member. May I make it very clear? Your lordship will find, so far as Anuradha is concerned, Aradhana is concerned, my lord, the total emolument is 69,354, page 56. My lord has got that? So, my lord, this is a mix and match which is abhorrent to the scheme itself.
Yes.
Now, my lord, coming to the other issues one by one. Now, I take your lordship to page 40. And I will rely on Pradeep Agarbatti. Kindly take, my lord, type 1, my lord has got that?
Yes, sir.
Type 1. Housing cooperatives formed exclusively by government employees, including police. Now, my lord, kindly take the term government employee, including police, will be defined as follows. West Bengal government employees, including police, the teaching and non-teaching employees of the government of West Bengal aided educational institutions. Now, 3 is employees of statutory bodies in West Bengal, government of West Bengal undertakings, the panchayats, including panchayat karmi within the state of West Bengal, municipal corporations, municipalities, local bodies within the state of West Bengal state government pensioners or family pensioners. Then if pensioners or family pensioners of West Bengal state aided non-government educational institutions, statutory bodies, state government undertakings, panchayats, municipal corporation, municipalities, local bodies, etc. So, my lord, now, my lord, kindly take, this is very interesting. Your lordship will take the expression statutory bodies in West Bengal, which is legible copy. Your lordship, if your lordship kindly takes our report, your lordship will find a better legible copy of this particular document.
That I have also noticed in the on the last night.
Yes. Kindly take, my lord, page 23. It will be, my lord, easy to read, my lord, subject to your lordship's kind consideration. My lord, this I employees of, these forms a group. This is a group of employees of II is group. My lord, kindly take III rather. The term government employees, including police, will be defined as follows. One is, my lord, West Bengal government employees. Then teaching and non-teaching employees of the government of West Bengal aided educational institutions. Then employees of, now ABCDEF. A is statutory bodies in West Bengal. My lord has got that? Page 23. I'm sorry, my lord. Statutory bodies in West Bengal. B is government of West Bengal undertakings. Well, one is statutory bodies. I give you a lordship straight away 2 or 3 examples. Employee of State Electricity Distribution Corporation Limited, statutory body. West Bengal Power Development. West Bengal Power Development Corporation Limited, statutory body. My lord, employees of KMDA, statutory body. Employees of SSDA, Sriniketan Shantiniketan Development. These are the statutory bodies. Now, my lord, kindly read A with F. It will all appear. This is nothing. Statutory bodies in West Bengal would mean only the West Bengal, the statutory bodies of West Bengal. Pensioners or family pensioners of West Bengal state aided non-government educational institutions / statutory bodies. The expression statutory bodies would mean and could only mean statutory bodies of West Bengal, that is the statutory bodies created by act of state legislature, namely the state legislature of West Bengal. Then, my lord, state government undertakings, panchayats, municipal corporation, municipalities, local bodies, etc. So, my lord, this A has to be read in conjunction with all the clauses, and it would appear, my lord, by applying the expression, my lord, it should take color from the neighboring items. My lord, because the group is employees of, then A, B, C, D, E, F, G, H.
So, Mr. Majumdar, I believe it would be your contention that in the event the term government employees, including police, are read as a whole,
yes,
the only perception will arise that it has given the meaning for the employees or the pensioners of the government of West Bengal, or its functionaries, or its instrumentalities, or its undertakings.
And
that is your content.
Yes, statutory body.
That is your content.
That is the sum and substance. I could not have put it in a better way. This is the simplest way of putting my submission, my lord. This is my entire case before your lordship. My lord, now kindly take, my lord. Along with this, my lord, kindly take.
As a matter of fact, Mr. Majumdar, interpretation is the outcome of perception and understanding.
Yes. And my lord, here the tendering authority, the authority which is floating this kind of issuing this kind of brochure is WB HITCO. If there is any perception difference, then obviously, my lord, the author of the document will have the final say, subject to your lordship's consideration, obviously subject to judicial review by your lordship.
Mr. Majumdar, it would be, I believe, it would be your further contention that in the event the term government employees are read as a whole once again,
yes,
it would reveal that the HITCO has no intention to offer the land to any other persons other than the functionaries of the state of the other than the employees of the government of West Bengal, or the employees of the functionaries of the instrumentalities of the government of West Bengal.
Absolutely.
And therefore, by no stretch of imagination, any other statutory bodies which are not the functionaries or the instrumentalities of the government of West Bengal will come under the purview of that.
I will not make any further submission in
Very
this.
good. That is your content.
That is my content.
Now, I believe you answered to that. The object there.
The object is that, my lord, kindly visualize one thing. My lord, the petitioners, I have already tried to demonstrate in my own humble way that these petitioners, the application itself is a deficient application. Even if we take their best case forward, my lord, even then, my lord, two of the petitioners, or sorry, two of the members, in fact, very interestingly, my lord, though there are 8 members, there are only 7 petitioners before lordship. Aradhana is subject to correction, is not a petitioner before lordship. Kindly note, my lord, make a note of that, subject to lordship's kind consideration. They say why Aradhana is not, he cannot file this petition or sign this petition, because Aradhana is outside India. Well, in paragraph 7 itself.
Very good.
Then, my lord, when we talk about allotment of land, when allotment of land is concerned, my lord, today, my lord, this is, my lord, this particular township was created to accommodate the middle class intelligentsia of the state. Now, who would comprise the middle class intelligentsia of the state? My lord, the government employees. And for the other persons other than government employees, they should be ordinarily domiciled in West Bengal. Not fleeting customers of, my lord, of any central government undertaking whose jobs are always transferable. And, my lord, I could not have put it in a better way. The first question that your lordship had put to my learned friend, yes, if you are aggrieved that this offends Article 14, why did you not challenge the brochure at the when it was issued? Why did you participate? And, my lord, interestingly enough, when we refunded the money, that refund was also accepted. We refunded sum of rupees 4 lakhs, that was accepted. They say we are accepting it without prejudice to our rights and contentions. They get back their money. Much submissions have been made on clause 12, which is at page 38. Well, I would say my client has been more than generous. Why, my lord? Because clause 12, if it had been employed in the strictest form, then, my lord, I was entitled to forfeit that amount. I did not do so.
That I have asked this question.
I did not do so. Now, my lord, straight away, may I take your lordship to the, my lord, as your lordship has seen from various judgments, my lord, may I start with the last one, which, my lord, 14, Article 14. Well, I am addressing on their issues, my lord. Kindly take, my lord, paragraph 2. This was, my lord, paragraph 1 and 2. This is 2021 15 SCC. Page 5.
Cited by them.
Yes, my lord. This is state of Tamil Nadu versus National South Indian River Interlinking Agriculturist Association. 2021 15 SCC 534. Well, I will just quickly run through the judgments. Yes. Then I will cite one or two of my own and then I will conclude. Because time is precious.
Yes.
Kindly take paragraph 1 and 2. What was the order, the judgment rendered by Division Bench of Madras High Court, and what was the subject matter of challenge? At page 542 of the reports, a Division Bench of Madras High Court of Madurai Bench allowed the writ petition filed by the respondent under 226 for quashing of GOM number so and so which granted loan to small and marginal farmers. The High Court held that the grant of loan waivers to small and marginal farmers to be arbitrary and directed appellant to grant the same benefit to all farmers irrespective of the extent of land holding. The government of Tamil Nadu issued GOM's number so and so granting a waiver of outstanding crop loans, medium term agriculture loan and long term farm sector loans to issue to small and marginal farmers. GOM 59 of so and so was issued providing guidelines for implementation of GOM 50. The guidelines provided for classification of farmers as small and marginal, the extent of landholding as mentioned in the landholding register, and the loan registered at the time of sanction of the agricultural loan shall be taken into consideration. As per the definition of small farmer and marginal farmer, it provides that a small farmer means a farmer who holds land of 2.5 to 5 acres, and marginal farmer means a farmer who holds land up to 2.5 acres. Subsequently, a circular was issued by the Registrar of Cooperative Societies providing for further guidelines for the implementation of the scheme. Mala, I will not trouble your lordship with all the entirety of the judgment. Kindly take my lord paragraph 34 and 35. What happened ultimately? Whether this kind of classification was upheld or not. The scheme in issue was introduced in pursuance of an electoral promise made by the then party in power in Tamil Nadu. The High Court seems to have been of the view.
Sorry, paragraph number
34 and 35, my
34 and 35, it does not match. It starts with the words.
The scheme in issue. But it's a live law printout. But last two paragraphs.
The scheme in issue was in.
Yes. Well, I was reading from SCC. I'm sorry, my lord.
No, it's all right. This is a paragraph 33.
Then 33 and 34.
Yes, sir.
The scheme in issue was introduced in pursuance of an electoral promise made by the then party in power. In Tamil Nadu, the High Court seems to have been of the view that because of the scheme was in pursuance of an electoral promise, it is constitutionally suspect. The view was made on an assumption that no study must have been conducted before the electoral promise was made. It is settled law that a scheme cannot be held to be constitutionally suspect merely because it was based on an electoral promise. A scheme can be held suspect only within the contours of the constitution, irrespective of the intent with which the scheme was introduced. The scheme propounded by the state of Tamil Nadu passes muster against constitutional challenge. The High Court has erred in holding otherwise during the pending granted broader coverage based on its assessment of the situation. The appeal allowed. Ultimately, my lord, this judgment was set aside. This is my first one. Then I think my learned friend also cited DS Nakara, correct? Kindly take DS Nakara. This is 1983-301 SCC 305.
Yes.
Only paragraph 2 will do. What was the scope in DS Nakara?
Yes.
Do pensioners entitled to receive superannuation or retirement under pension under CCS pension rules 1972 form a class as a whole? Is the date of retirement a relevant consideration for eligibility when a revised formula for computation of pension is ushered in and made effective from a specified date? Would the differential treatment to pensioners related to the date of retirement qua the revised formula for computation of pension attract Article 14 of the Constitution and the element of discrimination liable to be declared unconstitutional as being violative of Article 14? These and the related questions debated in this group of petitions call for an answer in the backdrop of a welfare state and bearing in mind that pension is a socio-economic justice measure providing relief when advancing age gradually but irrevocably impairs capacity to stand on one's feet. Malad, the scope of this DS Nakara judgment, Malad, the ratio laid down in DS Nakara judgment is not at all applicable to the facts of this case, where, my lord, this brochure and the steps taken leading to, my lord, formation of the contract and entering into lease is clearly a commercial transaction. And, my lord, today, what was the scope? My lord, your lordship would remember that in DS Nakara, cutoff date was fixed. Before the cutoff date, one kind of pensionary benefits was given. After the cutoff date, my lord, the pensionary benefits were reduced. Question arose that whether that cutoff date, my lord, is constitutionally valid on the unveil of Article 14, read with Article 16 of the and 21 of the Constitution of India. That is not this case at all. My lord, this is a case, my lord, and my lord, today, my lord, citing DS Nakara in the facts of this case, my lord, it is absolutely, my lord, not at all applicable. This is one. Now, Mahabir Auto. Then Mahabir Auto. Mahabir Auto is 1993 SCC 752. I'll take your lordship only to paragraph 11, 20, and 21. What was the issue? Kindly take paragraph 11. Before I take your lordship to this paragraph, the time during the course of this hearing, your lordship was putting a very pertinent question that why is it violative of Article 14? Because Article 14 perceives of discrimination within a class. The class here is, my lord, all the employees of state government and parastatals of state government, statutory or otherwise. My lord, suppose it would have been discriminatory. Suppose, my lord, the teachers of unaided educational institutions are left out from the ambit or from the zone of consideration. Or, my lords, say for example, the employees of municipalities are left out from the ambit of zone of consideration. But this is a class. So, my lord, another class which is entirely separate, that is the class of central government employees. Well, that class cannot be imported into this class so as to, my lord, make out a case of violation of Article 14. My lord, it is not like this. My lord, lordship has held it so many times. It is not like this. Was the most important question put by your lordship so far as, my lord, Article 14 is concerned. May I take your lordship to the 11, paragraph 11? We have heard learned so and Mr. Salves exhaustively. Further affidavits were filed so. And as such, the question involved was whether an instrumentality of the state can suddenly, arbitrarily, unreasonably, without any relevant factors and without any notice, determination, or proceeding, stop supplies of products. According to him, that had been supplied for more than 1 crore 11 lakh liters kg of product continuously and uninterruptedly over a period of more than 18 years. Dr. Singhvi suggested that the respondent IOC is an instrumentality of the state under Article 12 of the Constitution. From the nature of business carried on by the appellants, it was manifest to us that the supply of lubricants of the type with which the respondent had a monopoly could be carried on by the appellants only as a supplier from the respondent. The business was not possible otherwise. The respondent had a monopoly in that respect. This aspect is important. The respondent company was supplying from 65 to 83 large quantities of lubricant oil, and from 1983 to 89, supplies were continued on interim order of the High Court of Delhi. Supplies were stopped suddenly on May 27, 1983. There is no dispute that no intimation was given, no notice was given, no query or qualification was sought for, and there was no adjudication as such. It was held that the appellant firm was not entitled to supply. The stoppage of supply in May 83 was therefore bad. The appellant further contended that the case of the respondent company IOC was never made known or revealed prior to the counter affidavit in the High Court. So this was the case where, my lord, a supplier was continually supplying, that supply was stopped and the action of IOC was challenged. And the answers your lordship will find at paragraph 20 and 21. Well, judgment, well, we have all read, we have, as students of law, well, is an authority for what it actually decides, not for what that can be logically deduced therefrom. Well, these judgments have no manner of application to the facts of this case. Now, the last one on this line is Om Prakash Sud.
Yes. 1981 volume 2 essay.
Yes, my lord. Paragraph 3. Well, in this case, the issue was, my lord, the resin, my lord, this forest resin, this allotment of forest resin was not made in favor of the existing unit, but a decision was taken to allot resin in favor of the new units. And that was the subject matter of challenge, which your lordship will find at paragraph 3. But I'm not reading the entire paragraph 3 because, my lord, the time is short. Now, my lord, kindly take along with this paragraph 18. In this connection, these observations were made in paragraph 18. This was a case of industrial policy.
Paragraph number
18.
18.
18. So, Malad 18 has to be read with 3.
Paragraph 18 starts with
We are not aware.
we are not
Aware.
unaware.
We are not unaware. I'm sorry. So, Malad, this is the context. The context is otherwise. It was Malad stoppage of allotment of resin in favor of the existing. So, this is all regarding Malad this equality. Yes, equality. Now, I take your lordship to the nocitera society. Before I distinguish the judgments rendered by cited by the petitioner, my lord, may I refer to 2 or 3, just couple of judgments, just 1 or 2 judgments. Nocitera society आगे देखिए. না এটা 2023 4 এসেছে এটা দরকার নেই but 2023 4 SCC 312 I think my lord, it may be in your lordships.
It is in the file.
My lord, only just first head note, then couple of paragraphs.
Yes.
My lord,
Ram Sridhar Chimurkar.
yes. Family pension rule 59 54 14B of the Central Services Pension Rules. Family in relation to a government service import, adopted son or daughter, child adopted by widow of government servant, benefit of family pension restricted to child legally adopted by government servant during his or her lifetime. Adoptee must have a familiar relationship with the government servant during his lifetime. Child adopted by widow of government servant subsequent to the death of the government servant held is not covered by the definition of family under 5414B of the 72 rules cited as societies to be applied. Kindly take for once (21). But this was the provision, this was the definition of family, which was considered by the Honorable Supreme Court. 21.
Yes, sir.
My lord has got that. Now, my lord, kindly along with this take paragraph 33 rather. The canon of construction described in the principle nocitera societas may be applied to the present case. The said principle posits that meaning of a phrase must be construed having regard to the words immediately surrounding it. In the present case, the heirs listed under Rule 5414B of the CCS pension rules are the immediate dependents of the deceased government servant. Therefore, persons who were not dependent on the government servant prior to his death cannot be held to be included in the definition of family under Rule 5414B of CCS pension rules. So, my lord, a son which has been adopted by a widow after the death of the, my lord, the government servant cannot be, my lord, included in the definition of family under CCS pension rules. My lord, if the son had been adopted by the couple during the lifetime of the government servant, then obviously, my lord, there must have been a familiar relationship between the government servant on one hand and the adoptee on the other hand. My lord, kindly take how this color is being drawn. Kindly coming back to paragraph 21. Your lordship will find it talks about dependent parents, it talks about dependent disabled siblings, and it also talks about, my lord, son or daughter adopted legally. Now, son or daughter.
These are all beneficial legislation.
Yes.
These schemes have been introduced to tide over the difficulties faced by them on account of
That
the
is
death
the
of the
immediate need.
immediate needs.
So that, my lord, they do not face any financial hardship.
Actually, according to the law dictionary, what is the grammatical meaning of this maxim?
Nociter society.
Yes, what is the grammatical meaning?
My lord,
Which draws colors from the
an item or expression. May I give your lordship the exact meaning?
Exactly.
Instead of, my lord,
একটু আমার কাছে ল ডিকশনারিটা আনিয়ে রাখো তো
accident.
লাইব্রেরি থেকে
Another species
law
of
dictionary.
That, my learned friend, is absolutely correct.
What?
Wisdom generis and Nociter society is mostly same. Both are same. Wisdom generis, a meaning is to be drawn from the words associated by it.
Neighboring items.
Neighboring.
একটু আনিয়ে রাখো হ্যাঁ
Known by its associates. Known by its associates. এখানে আছে accident. ওখানে আছে না? ইনফ্যাক্ট এখানে প্রদীপ আগরবাতি বিল করা আছে। দাদা দিলে। This is very instructive, my lord. My lord, this is 2017 7 SCC 540. একটা দাও copy.
Has it been placed earlier?
I think so, my lord, but I have a copy right now because
what is the citation, sir?
2017 7 SCC
2017
7 SCC
SCC
540. এটা হচ্ছে পারলে অ্যাগ্রো।
No, sir, it is not there.
মানে I am handing up. Kindly take that. Josh সাহেবকে দিন। Kindly take, my lord, paragraph 42.
Paragraph 42.
42. Nociter society has been defined in this. They applied the principle of nociter society. Interestingly, my lord, Pradeep Agarbatti has been considered in this judgment. That is this 97. My lordship has got that. The rule of construction nociter society, as explained by Lord Macmillan, means the meaning of a word is to be judged by the company it keeps. As stated by the Privy Council, it is a legitimate rule of construction to construe words in an act of parliament with reference to words found in immediate connection with them. It is a rule wider than the rule of eusdem generis, rather than latter rule is only an application of the former. The rule has been lucidly explained by Justice Gajendra Gatkar in following words. This rule, according to Maxwell, means when two or more words are susceptible to analogous meaning are coupled together, they are understood to be used in their cognate sense. They take, as it were, their color from each other, that is more general is restricted to a sense analogous to a less general. The same rule is thus interpreted in words and phrases. Associated words take meaning from one another under the doctrine of nociety society. But this is how. And 43, my lord, Pradeep Agarbatti has been considered. Kindly take paragraph
So
40.
I believe you have taken the recourse to this maxim
Yes.
because of the fact that in overall reading
Yes.
of the definition clause as available in your brochure,
Yes.
it means that the statutory bodies in West Bengal, it means the statutory bodies of West Bengal.
Of West Bengal.
That is, I believe,
That
it
is
your
my
complaint
case.
and it is your
That is my case. And my lord, Pradeep Agarbatti, that is 1997, has been considered. In fact, one paragraph which my learned friend missed out perhaps of Pradeep Agarbatti. Kindly take, my lord, this was about sales tax. Paragraph 43 of this judgment, 2017. Entries in schedules of sales tax and excise statutes list some articles separately and some articles are grouped together.
Very good.
When they are grouped together, your lordship will
I
find.
understand your
Your
context.
lordship. So
And
these are-
then what will be your answer with regard to the object that you have your client?
May I just answer to your lordship regarding the object? My lord, this is as I pointed out to your lordship that this is a township set up in the vicinity of Kolkata. It is not classically Calcutta.
It is for accommodating
Accommodating
the domicile of the West Bengal.
Yeah, and the government employees, my lord, some preferential treatment has been given to the government of West Bengal employees and, my lord, the employees of the and, my lord, this is entirely, my lord, your lordship will kindly keep one thing in mind. My learned friend would not object to it. These entire lands, my lord, they are owned by HIDCO, but my lord, state is actually, my lord, controlling everything because HIDCO is a 100% government of West Bengal undertaking. My lord, the state will obviously take care of its own subjects. One of the most important subjects of the state are the officers of the state, employees of the state, those who are engaged in the regular functioning of the state machinery. All these officers, take for example municipality employees, take for example panchayat employees, they contribute to the growth and development of the state as a whole. It is not that, my lord, they are given at a concessional price. It is just a privilege that you may participate in the lottery. You constitute a separate class in yourself because you are responsible for, my lord, the development of the state as in general. And interestingly, this object point was never taken in the writ petition. I put the question to myself. I go to Delhi. DDA allots flats. Preferential treatment is given to the central government employees and the Delhi government employees. Delhi Development Authority. I go to Haryana. Allots flats and lands in favor of, my lord, preferential treatment. DDA, my lord, if I can just pull out one DDA side right now, your lordship will find every week there is one advertisement that preferential treatment to railway employees, preferential treatment to, my lord, PhD employees, preferential treatment to the CPWD employees. My lord, I am to take care of my subjects. And one way of taking care of the subjects is that to provide accommodation. But not at the expense of the state. They have to bear the cost. But other judgments, my lord, I have tried to deal with in my own humble manner, my lord. My respectful submission before your lordship would be that primarily this application, my lord, should not be entertained for the deficiency in the. And the secondarily, my lord, I've tried to, in my own humble way, I've tried to do so. And one more judgment, I'm sorry. My lord, so far as the terms of the brochure is concerned, one judgment I would like to cite.
That is in the file or it is a new one?
I think it is in the file. I think it is in the file. 2022 5 SCC 362 paragraphs 24, 24 to 26, 36.
2022, volume
5 SCC 362,
362, para.
24 to 26.
Yes, sir.
And 36. Right. 34, I'm sorry. And 34.
It is on which subject?
But this is on, my lord, the tender issuing authority. If any interpretation comes up in terms of the tender comes up for consideration, the interpretation of that tender issuing authority has to be given some credence. Last one paragraph from this one side from this. Yes. Kindly take paragraph 26 only. That will do.
Yes.
The above mentioned, it refers to several judgments. The above mentioned statements of law make it amply clear that the author of the tender document is taken to be the best person to understand and appreciate its requirements, and if its interpretation is manifestly in consonance with the language of the tender document. So, my lord, again, my lord, your lordship's observation has to be read as a whole.
Absolutely.
Yeah. And if it is manifestly in consonance with the language of the tender document or subserving the purchase of the tender, the court would prefer to keep restraint. So, my lord, this is the observation. And lastly, paragraph 34.
Very good.
But these are my respectful. Well, may I take your lordship's
Yes,
kindly?
yes. And prior to your
Yes. 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 I have many other examples, my lord. I didn't know that. No, no. Then, my lord, all of them can confirm.
Yes.
I will reply in 5 minutes. I'll take not more than 5 minutes,
Yes.
my lord. My lord, before replying, what I can understand today, that if, my lord, with deepest of regard, but still I cannot help myself from submitting, that if there is a direction to report and to file a report on affidavit, then nobody knows what is the case of the other.
Very good.
Now, at the time of submission, my learned friend has taken 2 points of eligibility. Right now, I have the answer of it. But the problem is this: since that point was not taken in the report on affidavit, I cannot submit those papers in my bio.
Very good. It will be taken care.
But so far this point is concerned, I have a duty to reply, madam. First point, my learned senior friend has taken that 2. So far the other 6 are concerned, my lord, admittedly those are statutory bodies. Now the question is another 2 person. One is Anuradha Pandey, another is some Amit Kumar, some gentleman is called Amit Kumar under the labor welfare. Now, my lord, immediately I sought the information from my client. Luckily they were here. Otherwise, I would not be in a position to reply this question because I am not prepared for this. So far, my lord, the civil aviation is concerned, my lord. I am just shared with the relevant information. That particular division is formed under the Aircraft Act 1935. That is a separate entity. That is also a statutory body. And that body is established under the Aircraft Act 1935, which has been later on amended by the Amended Act 2022. If my lord allows me, I can, my lord, file that particular document supporting a that is not there, my lord. It's through.
Oh, that's not,
And so far the another lady, that is my lord Aradhana, the labor welfare, my lord, that is also a separate division, my lord. Labor welfare is a separate division, and I am told, rather the information, so far the information shared with me, that the oldest division of Ministry of my lord Labor and my lord Labor and Employment, and that is established under the Mica Mines Workers Welfare Fund Act 19. I'm sorry, my lord. She has not taken proper note, my lord. But be that as it may, my lord, that organization, that particular division, that is labor welfare organization, to which Miss Aradhana ki title? Aradhana Pandey is belonging to, that is, and my lord, the that is called the Labor Welfare Division, headed by the Director General, and that division is the oldest division of Ministry of Law and
Ministry of Labor.
Ministry of 19. And that is established under Mica Mines Workers Welfare Fund Act 1941. So that is also a statutory body. Only difficulty is that point was not raised by them in their report.
Director of Aviation is concerned, that is a statutory body.
Body established under the Aircraft Act 1935. 1934, I'm sorry, my lord, 1934. These points were not raised. I cannot say they cannot raise, but since it was not raised, my lord, I did not file a supporting documents to substantiate this, my lord, contents. At their, my lord, convenience, they can raise any point, I can understand. But had it been
Aircraft Act?
Aircraft Act, my lord, 1934. That is the, my lord, Civil Aviation Department. And so far the Ministry of Labor is concerned, Anuradha Pandey, Aradhana Pandey, that is, my lord, that is the, my lord, Labor Welfare.
Ministry of Labor, it's
Labor
purely
under
central
the
government.
Ministry of Labor, but that was established under Mica Mines Workers Welfare Fund, 1941.
46.
Oh, that's fine.
1946.
That's all. Asu, take down.
No, it is not, I am not finished. So far the salary part is concerned, my lord. Admittedly, my lord, it is showed it is below 80,000. It is admittedly. But my lord, that particular salary certificate was for the month of March. And after the deduction on account of, my lord, the income tax, that amount has come below 80,000, my lord. His earning is much higher than 80,000.
Then what is the gross salary?
Gross salary is much more. It is not reflected here because, my lord, after deduction, that particular salary slip has been attached with. But otherwise, nobody would have been so foolish, my lord.
No. We are concerned with the gross salaries.
Gross salary is within the bracket of 80,000. You can take my lord. On instruction, my lord, I am making this. It is not reflected here because after the, my lord, income tax deduction, my lord, this total income has come below 69,000. If, my lord, desire again, my lord, on affidavit, my lord, I can my lord, submit the proof of salary so far the bracket of 80,000 is concerned.
No. That is the 69,000 and what is the gross salary? And net pay is the 63,269.
Well, I am told, my lord, this is not.
No, just you see.
I can see here, my lord.
Those are the total emoluments is such. Government recovery is such and such.
That is required.
Net pay is such and such.
The total income tax part is not reflected. The deduction on account of income tax is not.
Any other points, sir?
So far these are the, my lord, technical ground I am aware of. My lord, so far the points are concerned, my lord, refund, my lord, my senior friend has taken, my lord, refund we have taken. There is a letter, my lord, that refund was.
Yes,
it was
without prejudice to your rights.
Yes, without online transfer, I cannot physically restrain them from sending the money. Secondly, my lord, my lord, so far the object part
Don't
is,
go to the factual aspect. I have taken care. I will take care of it.
my lord,
If you have got anything to say about law point, I can understand.
law point, my lord, object part, my lord. Object part, I can understand two things, my lord. One
That
is
you have submitted. I will
yes,
not
my
hear
lord,
it.
the ordinary.
Sorry. No. Take down.
My lord, ordinary domicile point, my lord, senior friend has taken.
Very
good. That is
This court has
also relying upon the DDA brochure, my lord, kindly see whether any restriction is made for only for the daily. Kindly see once, my lord. The DDA brochure I am carrying. Delhi Development Authority, there is no such.
I will
only the
not.
citizens
I
of
will not
India.
see that.
Because that point raised by my senior friend, my lord, that is DDA or other state, my lord, preference has been given. It is not so, my lord. Any citizen of India can apply for any plot of land under DDA, my lord.
এইটা না আমি আমার
Well, since learned friend raised this topic, that is why.
Lordship, push in that matter. Item number 12, Lordship. Would it be your Lordship pleasure to take it up tomorrow? Justice Chatterjee's court, your Lordship. Yes, Lordship, tomorrow it can be fixed at same time, 2 p.m. 2 p.m. Obliged.
Same matter, which was item number 61, Lordship. Lordship, can it be fixed on the day after tomorrow, Lordship? Lordship.
What is to say?